A special edition of Morning Line. I am Nick Barris, and we are coming back with you today as we continue our gavel-to-gavel coverage of the Caitlyn Kaufman murder trial. And today we expect it to be quite busy, and I frankly think that this trial will conclude today with verdicts. To talk more about what we can expect as we guide you up to action in the courtroom, which is expected to begin hopefully by 9 o'clock, maybe before then. But News Channel 5 legal analyst Nick Leonardo joining us. How are you?
I'm all right, man. How was your weekend?
Well, it was half a weekend, right? You and I were both here, and many of you joined us during our coverage on Saturday, and Sunday was off. They wrapped everything up. Defense rested on Saturday. Prosecution had rested the day before, and back today for closing arguments. What do you think? How things will go today? What do we start off with? It'll be
the judge will ask them, do y'all have anything we want to take up before we begin? And she hates asking that, we've learned.
I know, because she's afraid,
you guys always have something. But so we'll hear closing arguments today. It'll start off, the state and all criminal prosecutions has the burden of proof, so they'll get two bites at that apple. They'll get to go first. All right, and then they'll have the last word. So they'll go, and then you'll hear from each one of the defendants in their closing, and then the state will have the final word. And at that point, Judge Dalton should charge the jury and read the jury instructions and then send them to deliberate. But I have a sneaking suspicion that we may be able to get that in before 12:15, because that's a tall order, that's a lot, or she may break for lunch early, come back and read the charge. And it's interesting to point out that judges can do this differently, and I've seen it in different jurisdictions where they will read the jury charge, then they will have closing arguments so that the lawyers can comment on that jury charge. Okay?
So that could happen first, maybe.
That could happen first, but but again, it's either way is fine under the law, and it's up to the judge. I'm not sure how Judge Dalton does it. I would imagine maybe she would do closing and then read the jury instructions.
Okay, so that's how it'll play out, and then after they get their instructions and everything's completed, they deliberate. And we sit here and we will wait for a verdict coming back on the two defendants, Devonta Hill, James Cowan. And during that time, of course, we'll have the phones open and we'll get everyone's opinion on where things stand. I guess Saturday, for those of you who maybe didn't join us, the big news Saturday was that Devonta Hill took the stand in his own defense. And you and I talked a bit about that, when we had a moment Saturday, but maybe to recap a bit today. He got up there, and if possible, I think it was a Hail Mary on his part, because he's charged with first-degree murder. In my opinion, he was already toast on that charge to begin with. I think he made things worse for himself, even though he was already there, and I think he may have damaged Cowan as well.
I mean, I agree with you 100%. I mean, out of all the trials we covered, and maybe it's been close to 15 now.
Yeah.
We see every now and then we'll see a defendant testify on their own behalf, and I'd certainly think that Hill had an opportunity to score some points, but it just didn't work out so well, because I didn't hear, again, he's a young man, very, very young, like 22, 23 years old. But nonetheless, I didn't hear him one time in his testimony apologize to the Kaufman family or say the words, "I'm sorry."
No remorse.
Well, at least it didn't come across as genuine remorse. And then some of his testimony was also inconsistent with what we had heard from Detective Gish. He testified that he didn't know that he had killed anybody, or didn't think he'd killed anybody. Well, then we heard from Detective Gish that it was just minutes after the scene. He was Googling that on his phone, even before the police department knew that there was any sort of crime that had been committed. And so, I mean, I think that the jury probably picked up on that. Clearly, they picked up on that. But I don't know that he helped himself, and frankly, I think that he may have done such a job that it's going to actually pour over onto Cowan and not help Cowan, because he was trying to distance himself, if you remember, say Cowan didn't know anything about it, he had no idea. But I think the most damning part of the testimony that he gave is that he opened the door early on in his testimony with his lawyer, and opening the door means that there were some juvenile convictions that would not come in, but he made some sort of statement, a blanket statement that
what was it? I think it was along the lines of, when I shot the gun, I wasn't sure that it might hurt someone, or some like that. And well, what do you mean you didn't know if it would hurt someone? The door was open.
That's exactly right. And so then we heard Jan Norman, her very last question, or close to her last question, was asking him about a prior juvenile conduct where he shot his grandmother, he shot a 6-year-old and 12-year-old cousin, and I think missed his mother. But nonetheless, that's pretty I think if a jury hears that, where there's smoke, there's fire, and I think that was all that you needed to hear as a juror. If you had any doubt, the fact that he's already shot 3 family members, now he's had a senseless act of violence again, I just don't see a jury feeling connected or feeling much, feeling sorry for him, frankly.
I agree. Now, as far as Cowan's concerned, the question on him, he was behind the wheel, okay? That's known now for certain. He was driving. And you can make the argument maybe he could face a lesser included offense if you believe that he was just driving and had nothing to do with it, as Hill kind of said. Look, he had nothing. Hill kept saying nothing.
That's right.
I think he went too far even saying that, where it made you think that he's trying to protect a fellow gang member.
That's exactly what I thought. Because he might thought, we're going to probably going to get, they both know they're going to get some jail time out of this. They're already in jail. But I think you're exactly right that they're both in the same gang, and I think he was trying to save a fellow gang member, because what didn't resonate with me is they asked him, once you shot 6 times, what did the driver say? And I don't think he said anything. I really can't remember. And I'm thinking to myself, now come on, there had to be an argument in that car if he was absolutely unaware.
Right.
But I think in the closing argument, we're probably going to see Jan Norman maybe or Roger Moore take the murder weapon in that case and click it 6 times and think about how long it takes to pull that trigger, and each one of those,
well, and keep in mind,
evidence premeditation.
Remember too, where he said, I don't remember anything that he said right when he did the shooting. But then they asked him about, what about when you left later? And he goes, well, he clearly remembered later that he told me, why did you do that? You were bull cursing or whatever, the word, you were tripping. He remembered that pretty clearly. So I find it hard to believe that Cowan didn't say anything. And I think what the prosecution has tried to say through ballistics and everything else is that after she allegedly cut them off, I think Cowan accelerated to the point to get Hill in position to fire.
Yes.
And if that's the case, he's every bit as guilty as the person who pulled the trigger. And I think there's a good chance he gets first-degree murder as well. But there's where there's wiggle room. I'll tell you, if this jury comes back with anything less than first-degree murder for Hill, there's a problem with this jury. There is a problem with this jury because that is a no-brainer. We've done trials for years. I've never seen a more clear-cut no-brainer than this one.
Well, and you're going to hear, if you were watching this and paying close attention, you hear a lot of these experts testify, and you keep thinking, what are they trying to get at? What are they trying to show? And so you're going to hear in closing arguments, especially from the defense and the state, what they're asking you for and what they would surmise the evidence shows. It's important to point out, too, that what lawyers say in opening and closing arguments is not evidence, but if you pay close attention to the closing arguments, they're going to try to put a neat bow on this and ask the jury to come back with a verdict that reflects what they're asking them to do.
Exactly. Who do you think our first call is from today?
Ann. We used to be Joe.
Yeah, right. Now it's Ann. Ann, good morning to you.
Morning.
You're jumping in. Go ahead.
I took a few minutes yesterday to look up Mr. Cowan's arrest record. Since 2010, that young man has been arrested 26 times, the least of which was a driver's license. And then it starts with contributing to a minor, felony weapons charges 5 times, evading arrest, aggravated robbery, and the list was too extensive to go on because within those 26 arrests, you had to individually count up all the different charges, and they exceeded well over 200. And the young man right now owes over $35,000 in fines from these convictions since 2010. So anybody that wants to question Mr. Cowan's credibility in this needs to look up his criminal record. Now, can any of those be brought up in the sentencing phase is my question to you, Mr. Leonardo. Because this is more than an extensive criminal history. So, Mike, I wondered all weekend long if any of that can be brought in when it comes to the penalty phase.
And real quick, by the
Great
way,
question.
everything she laid out there was, why Cowan didn't take the stand.
Yes, clearly.
Because all of that could have been brought up. I mean, Hill may be the trigger man here, but clearly Cowan has the more prolific criminal history as an adult.
No, I mean, that's exactly why Mr. Cowan did not take the stand.
Jury doesn't know that stuff.
Jury doesn't know that stuff, and the state filed a notice at the beginning of this trial, basically putting the defendant on notice that, hey, if you testify, we're going to bring this up, which is required. And so the state did file those notices to use the appropriate convictions, felony convictions that are less than 10 years old, and the like. But as it pertains to the criminal history of each one of these defendants in sentencing, that is a threshold issue, and that's something that the court's going to look at, because the court has to fashion a sentence between so many years. Like, it's 15 to 60 for a Class A felony, but if you don't have any priors or one prior, you could be looking at 15 to 25. So the court's got to look, start at the midpoint, and they'll look between 20 and 25 years, and part of what could increase your sentence within that range are your prior convictions. So clearly the prior convictions are going to be huge, and from what I'm counting here, you might very well see that if there's a lesser offense, that Mr. Cowan may very well be a persistent or criminal or career offender, which would put him at the top of the range.
Is that where they call them ranges, right? Range 1, range 2, range 3.
Based upon how many priors you have.
Good question, Ann. Listen, we need to take a break on that note, and we'll come back. We can take more phone calls. We'll set you more up on what we expect this morning. As soon as we get a live picture in the courtroom, we'll take you there. We think that they'll begin with closing arguments and maybe a few other things they need to deal with administratively at 9 o'clock. But stay with us and give us a call if you'd like to join in the conversation. 737-7587. Also streaming live right now on YouTube and Facebook at News Channel 5. We'll be back with more right after this. Line. Thanks for joining us. Nick Barris along with News Channel 5 legal analyst Nick Leonardo. You know he means business when, hold it up, What'd you bring with you today?
The hymnal.
The hymnal. What is
The
that?
criminal. It's called a criminal justice handbook, and it's put out by the Tennessee Administrative Offices of the Courts, and it has all of the criminal law. So all of the Tennessee Code is in those big green books, right? And the legislature passes all that, and so instead of having to carry 3 or 4, big green books around, the ALC makes this handy little criminal justice handbook that has all the criminal offenses, that has some of the DUI stuff, some of the sentencing important statutes in there, as well as they also have the rules of criminal procedure and the rules of evidence, and then at the back of the book they have what's called the Tennessee sentencing grid, which is a little grid there that
I've seen that before.
So
you've shown me that.
It's kind of a cheat sheet for criminal law, something this big as a cheat sheet.
Well, I'm really glad you brought it, and he'll be referring to that during jury deliberation. He'll walk us through, which I think a lot of people are trying to get a handle on. We don't have to do it now. We'll take calls because it takes a while. Defining premeditation and how, because that's really what's going to decide whether or not it's first-degree murder or lesser charge
or
for both these
intentional
defendants.
Or knowing, or reckless.
It can be confusing, and the guidelines are there.
Well, you think what the word intentional or knowing means, but man, read this and you think I'm not any clearer now. I'm more confused than ever, kind of.
Yeah, you're right. So we'll go over that. We will for sure. But let's take some more calls. We'll go next to James. James, good morning. Hi, James.
Good morning, fellas.
Hey.
Good morning.
I have just a comment here.
Okay.
If or when they're found guilty, I hope the prosecutor says you could have shot her tires out or her engine. Now you face possible life, no parole, fellas, no more drinks, drugs, or women. So each day, month, year that goes by, well, your judgment was stupid. See you in 30 years, and that'll take the cocky wind right out of their sails.
Yeah, well, I'll say this. They'll probably realize it, but there's no chance for the prosecution to address them after the conviction. Again, there will be a sentencing hearing, though, correct? And that'll come later with the judge, and he's going to get to hear from the victim's family at the sentencing hearing down the road.
And there will be a sentencing hearing. However, if they are convicted today of first-degree premeditated murder, that is a life sentence, and I think you will see, if there is a conviction on the indicted offense, that Judge Dalton will go ahead and place those sentences into effect. They would still come back for a separate sentencing hearing, but I think you would see her go ahead and do that and have them remanded to the Tennessee Department of Correction.
So they'll already then be moving into the prison system
and by the time they come back, they will already be in the prison system.
Okay, gotcha. Thank you, James. Let's go next to Robert. Hi, Robert. Good morning.
Morning, fellas. I know the heel Saturday, he definitely didn't help his cause any from his smugness up there on the stand. I know he had to get up there, but he could have done a lot better. Well, what stood out was the fact that he knew from the time he left Hermitage, every step he made. He didn't remember shooting the girl, but yet he remembered immediately after that getting off West End Avenue, going to Bellmead, picking up Cowan's girlfriend, and him taking him back to Panorama in Madison. He knew all of that, but he forgot. He didn't remember shooting a girl. Mm-hmm. Now, okay, he said, they asked him, why did you lie when Detective Dickerson was questioning you about this? And he knew that she had died, everything, and he said, I was protecting my family. Yep. I had to remember my kids. I had to remember everything about me. And when he said that, if that jury didn't recognize that as zero remorse, that he thought of them more than he thought about a girl that he had just killed, he did not know, he knew he would kill her if he shot at her because of shooting his grandmother and brothers and whoever he shot before, that was definitely no remorse right there. And I hope Jan brings that up in her closing arguments today. I've enjoyed y'all's coverage of this. I really have. I hope we do it again. Thanks a lot.
Thank you, Robert. I felt the exact same way that Robert did when I heard him say that.
And it's great that you get these callers because you hear what people pick up on, and that's a great point, because I remember that. I just didn't write it down, but I remember him making that statement. That's why he lied, was to protect his family and his kids. Not that I'm scared or anything like that. And I think he's right. I think the jury picks up on that. If you pick up on that watching it on TV or on a computer, can you imagine if you got a front row seat?
Oh yeah.
I guarantee you that the jury picked up on that.
Absolutely. Good point. Let's go next to Kim. Kim, good morning, Kim.
Hey, good morning. How are you?
Good.
Hey, I have a question. Do you know if after they picked up the girlfriend, did they get back on 440 to go back? I mean, if they did, they would have seen her car. Would have said, oh, that's the car we shot at, or does that make sense?
Yeah. Apparently they didn't, because he was Googling trying to find out. Well, I'm trying to get the timetable. How long after it happened do we think? And I thought the girlfriend might have been involved somehow, maybe not knowing. Did they burn the Cadillac?
I'm not sure how long. I know
later was that?
I know that it was a matter of under 5 minutes that they were picking up the girlfriend.
Yeah, that's right.
From 6:08 when her car stopped, according to Detective Gish, and then maybe 6:13 or so we're at the light, okay, trying to get on to Woodmont, which is Woodmont and Hillsborough Road, because they found several shell casings there at the corner of Hillsborough Road and Sharondale, if you remember, which is the first road as soon as you get off.
Okay, right. And so, I don't believe that they came back and saw the scene. I don't think so.
I think if you're headed back to PA, you're going to not take a left on 440, you go the other way.
There you go, right. But fair question. But I don't think that's been brought up either, so I don't think they did. Let's go next to Larry. Larry, good morning. Hi, Larry.
Good morning. How are you this morning, Nick?
Good, Larry. What's on your mind?
I have a question.
Okay.
Do the defendants have court-appointed attorneys, or were they able to fund their own?
Okay. Yeah, they're all indigent, so they were appointed. Now, the public defender's office can represent Hill, but the same office could not also represent Cowan, so there had to be an appointed attorney
because their
for him.
interests differ. This is a prime example of how their interests differ. One's the trigger man, one's the driver, and so clearly, even though they're on the quote-unquote same team, they definitely have different interests. And so once the public defender has one of these individuals, then the court will have to appoint a lawyer and a private attorney that gets paid through the administrative office of the courts or off of taxpayer dollars. And that was Mr. Bunkabo, who's been around, probably close to almost 30 years, 27 years or so he's been an attorney. And so he is appointed by the administrative office of the courts. All the experts that you've seen on behalf of the defense, those were paid for by taxpayer dollars.
There's really only one expert besides Morris, who didn't take the stand, but just one. So, but in general, taxpayer dollars have paid for all their legal defense, which is the way it's set up with public defenders. You have to have that.
And what's very interesting, and you saw it kind of play out here, is that the judge would, they would make an application to the judge for an expert, and the judge would approve those funds, and then the administrative office of the courts would pay that expert. But the interesting thing is that we're paying this expert with taxpayer dollars before they come to court, and we determine that they can actually testify as an expert, which is kind of fascinating.
I didn't know that.
Yeah.
Interesting. All right, let's go next to, I believe, 6 is Melba. Good morning, Melba.
Good morning, sir. I'll make this real fast. Thank you for all your coverage. My first question is, what about the girlfriend? She had to know about all this because she helped them get rid of the car. That's evidence of murder. Her sister let them back the getaway car and where she was renting. That's an accessory. They were all at Panorama involved in the gang. They weren't brought on the stand. That makes them accessories just based on knowledge. Cohen knew the shooting happened. He didn't go back to render medical aid or anything. That makes him as much as guilty as pulling the trigger. I think he should be charged with first degree or second degree. Both of them, they both get no less than second. Definitely not second. But he didn't go back. They were all involved in this together. And what about the gang activity? I like to see you do a show with the Metropolitan Gang Department, talking about how this is going to affect the gang activity that's currently existing in Davidson County and the state of Tennessee. And thank you all very much for all you're doing.
Thank you for your call, ma'am. I appreciate it. As far as the gang activity and how that plays out, it's been mentioned in this case, but we don't think this shooting was necessarily gang related. I mean, he didn't go there and say, well, I thought, along those lines, this was a gang member I was shooting at. But he was driving around with a gun on his lap, which makes you think the guy's kind of edgy, like someone could show up at any moment.
And the gang stuff was already into evidence. We already heard from Odom about the gang affiliation. There had already been a picture that had been presented of Mr. Cowan and Mr. Hill together. And so I almost feel like that would make more sense to me, because I mean, right, as far as the truth is concerned, that's why you were so on edge, is because you were thinking that someone was after you potentially.
But he never said anything about that. I thought that would have maybe given him something to hang his hat on, that why he did it. I mean, it's horrible that it was this woman, but he thought it was a gang member that cut him off, so he shot. He never went there. He didn't take that.
Never went there.
Real quick, just we have to go to a break, but with regard to the girlfriend, clearly, I mean, authorities vetted her, and had she been involved, she would have been charged. I was kind of curious. I'm guessing her name was probably on some of the witness lists, but for whatever reason, the prosecution chose not to call her. But there's no indication that she was criminally involved in this case. And trust me, if they had found a link that was criminal there, they would have charged her as well, I think.
No, but I will say that Ms. Carter's cell phone was key here into a lot of the evidence that Gish was able to testify to.
Because of the calls that she received.
That's right.
But she was not involved per se. So let's take a break. When we come back, more of your phone calls. We're watching, counting down to things beginning in the courtroom. We expect no later than 9 o'clock with closing arguments. So stay with us. And thanks for joining us on this Monday. The two Nicks here, counting down to activity in the courtroom. And this would be, let's see, jury selection was Monday and Tuesday. So then Wednesday, Thursday, Friday, Saturday. This will be day 5, really, outside of jury selection of the Caitlyn Kaufman murder trial. And I think it wraps up today.
Yeah, I mean, I think it wraps up today as well. I mean, if we don't have a verdict after the first couple of hours, we've got a couple of holdouts on some lesser charges.
Exactly. So closing arguments coming up at 9 o'clock. Let's take some more phone calls, and we'll go next to, I believe, Keaton. Keaton, good morning. Hi, Keaton.
Hey, Nick and Nick, how are y'all?
All right, sir.
Hey.
A little coincidence, both Nick and Nick. But anyway, so after the closing arguments, I'm sure the judge is going to give the jury instruction. Unlike the trial we saw in Wisconsin about the sovereign citizen, how many pages do you expect the jury selection or jury instructions to be? And can you explain how the deliberations work in the jury room and how could work? Thank you.
Thank you. All right, take it away.
So are you Nicholas or are you just Nick?
I'm Nicholas on my birth certificate.
Okay, I'm Dominic. So, but
Dominic.
I never knew you were Nicholas.
Nicholas and Dominic. Okay.
So, Keith, how many pages the jury charge is? You're looking somewhere between, I'd say at a minimum, maybe 45 pages all the way to 60 pages.
Is she going to read all that?
And of course, the law requires her to read all of that. And, it's kind of difficult to do. I mean, I know right now where I'm sitting, I couldn't read that without mistakes. I need to get my eyes checked again, but it's a whole lot to read. And so she will read that, and then they will go into the back, and then they will take the exhibits with them. The court officer will, if there's any smoke breaks that need to be taken, they'll take some of them to smoke. I mean, that's just the reality of it. And then the court officer who is sworn in will explain to them, okay, I'm going to shut this door. Once I shut, you can begin. When the door is open, there's to be no more deliberations at all. And he'll put them in there. And the instructions say that their first order of business is to elect a foreperson. Okay, and the job of that foreperson is not some authoritative role to crack the whip and say this is how it is and this is what the evidence shows. The job of the foreperson is to continue to make sure that deliberations are continuing, and we're not talking about who just made it into the Super Bowl and going to Disney over here. It's like, hey guys, come on now, we got to focus on this, all right? And so then they'll elect that foreperson, and then they'll begin deliberations. And if they want to rewatch something, they can do that. They'll have all the exhibits in the room. If they want, they may not bring the gun in. If they want to see the gun, then they might bring the gun in. It's like in a lot of these cases where you have lots of cocaine and stuff, it's there, but they don't ever ask to necessarily see those kinds of things. But and then they will go through the jury instructions, and it'll tell them to start off with the first charge, and they'll tell them the elements and what they've got to, what the state's got to show.
So what she reads, they will give a copy of that to have back there.
Exact
I'm
same.
going to say this about jury instructions. When she's reading it, it is mind-numbing, and I don't see how anyone who's just sitting there hearing her read it can absorb it all. You'll absorb some. That's why it's important to have it with you. And another word of advice, if you're ever in the courtroom, journalist or watching,
get out of there.
Get out of there before they start the jury instructions, unless you're just a glutton for punishment, because once she starts reading, that door is locked. Unlike during other times during the trial, you can walk in and out. Jury charge or jury instructions, they close the door, and you're there for the duration.
And it's a cure for insomnia, as I like to say.
And I don't mean it. I'm just saying it's important, but that's why they'll have a copy with them that they can refer back to. Because when she's reading it, you can only absorb so much. It's overwhelming.
Well, and if they have a question, 8 out of 10 times when the jury has a question, they'll come back into the courtroom, call the parties back in, and the judge will just refer them back to the charge, trying to say, look, folks, the answer is in this big, long document that we have here.
We wanted you to tell us is what they want.
Right.
No, you got to muddle through that. And it's
a good
complex.
question.
Yeah, good question. Let's go next to Carrie, I believe. Carrie, good morning. Hi, Carrie.
Hi, good morning, gentlemen. Thank you all again so much. You always do a great job.
Thank you.
So, speaking about jury deliberations, I did have a question when Miss Ann called in earlier, who she, by the way, is fabulous. But you know how she was able to just look up that information on Mr. Cowan's lengthy critical history? That is public knowledge. So let's say a juror goes home at the end of each day because they're non-sequestered, and while they know they are not supposed to research, deliberate, or anything, but let's just say their spouse is sitting at the table while they're having dinner and says, man, you would not believe what I found out today, and it just proceeds to freely spill out the information in which the juror wasn't asking for, talking about what. Anyway, my question is, I guess that's a risk you have when you have a non-sequestered juror.
Exactly.
So what is that juror's moral, I guess, or legal obligation at that point should they become privy to that information? Thank you all again, and I'll let you go and appreciate you.
What an interesting question. What is it? And that can absolutely happen. And it may not even be a family member. The juror themselves may, on their phone, check those things out. You've said as much.
Well, and I say it again. I mean, 25 years ago, we didn't have to worry about that because it took a lot of shoe leather to go down to the courthouse to pull a file. People would see you. I mean, the newspaper, it was a little easier to avoid that. But now with everyone having one of these, I can look up anybody's criminal record record I want to in a matter of seconds. Anything about, you Google a name and all this stuff comes up. And so the law runs 25 years behind. The changes in the law run 25 years behind technology. Okay.
Yeah.
If it wasn't for the pandemic, all the lawyers and judges would be like, "What's Zoom?" Okay. And so clearly, we need to examine and look at how juries are functioning with this, because there are some sequestered juries where judges will let them have their cell phones. And so the judge gives the instruction, as you've heard Judge Dalton do many times, again, don't look at anything about this case, don't investigate anything about this case. I mean, she tells them that, but because it's on TV, because there's 14 people who've been sitting here as long as we have, they go home and their families are watching what they're watching.
Sure.
And so the likelihood that conversation at the dinner table is occurring is tenfold. It's increased tenfold because of the coverage that we provide. But again, General Assembly's in session. I don't particularly have the answer, but I think we all can agree that there's a huge risk and there's a huge problem, and it's just too easy to get information. And we don't even know, again, if the information that people get on the internet is correct. I mean, there's an epistemology problem.
I don't know what the solution is. That you simply cannot sequester every jury and take everything away. There's no money for that. It's not going to happen. So I don't know how you stop it.
Well, but maybe if you're on a jury that your internet service provider information is given, and then if there's anything Googled,
then you face punishment.
You face punishment for
it.
Right.
As far as her question to this, though, and I know we've talked about that before, but is there any responsibility for a juror who So if in that case you're a juror that maybe heard something at dinner and you're like, whoa, I didn't know he's got priors, are you supposed to go tell the judge that?
Well, the judge didn't say do that. The judge said, don't do it in first person. But yeah, they would have a duty to come and tell the judge, hey, I've heard something. And, I guess if I was the judge, I guess we would have a hearing on the record to determine, could you disregard that statement? Can you set that aside? And if you couldn't set that statement aside, then clearly, we're down to 13.
I'm only going to a judge. First of all, I'm not going to share what I've learned with the other jurors. And two, I'm only going to the judge if I think I can't set it aside. Otherwise, I'm not saying a darn thing.
And you're going to be scared. I mean, people, this is a big, huge courtroom. You're thinking, oh my gosh, is she going to put me in jail if I've done something wrong?
But if I felt I was going to be jaded and I just couldn't get past that, I would tell the judge. Otherwise, I'm not saying.
But we have a rule of evidence, Rule 606, I believe, and Tennessee Rules of Evidence talks about extraneous influences on jurors. And so, usually you see this come up after there's a conviction, that some juror comes forward and some juror says, yeah, my wife told me this, we talked about that. And so anything that's extraneous could be a basis for a mistrial.
Right, which is a big, big problem. Let's go next to, William. William, good morning. Hi, William.
How y'all doing? Y'all done a great job of covering this.
Thank you.
Thank you.
This is the first one I've ever watched, but I did notice a few things.
Okay.
Mr. Calvin's been a smart son of a gun. He didn't take a stand because he couldn't say nothing to help himself. Mr. Hill, he's already admitted he's a shooter, but at the same time, what I didn't understand, I understand a few things. I understand why he's saying, I don't recall. That's the reason I don't want to say legal way of saying it. But what really got me was I never thought, why didn't they ask? It's December. It's been raining. It's getting close to dark. You're riding down the interstate at 70 mile an hour with the window down. He had to roll the window down to put the gun out. And they don't want the other boy on the stand because he don't want to say he paced the car to do it.
Right.
But it just got me that nobody thought about, well, he had to roll the window down, but he's saying the whole time, I don't recall. And I think they done a good job of getting him.
Sure.
Don't recall. But he guided me many times as he said it.
Now, if you remember, he did say in his testimony, if you caught this, that they were smoking marijuana, and that he had already rolled the window down, so some of the smoke, could bellow out and it wouldn't smell.
That was his explanation for the window being down. Good point. But other than that, the caller's right. It does appear as though Hill had selective memory. Some things he just didn't remember, and other things he did, including what Cowan told him before and after. Selective memory. The jury, you think, picks up on that?
Sure.
You bet. Let's go next to Peggy, I think. Hi, Peggy.
Hi, Peggy. Hi, Peggy.
When that happens, that means Peggy hung up. We get feedback. Sorry, Peg, we missed you. Let's go next to Linda. Linda, good morning. Hi, Linda.
Good morning, Nick times two. I've had several things going on as distractions around the house, and I heard about the burning of the Cadillac, but where did that happen, actually? That's my question, and y'all have a good morning. Thank you.
So there was a witness, I think Miss Reese, if I remember
looking
correctly.
For her. Miss Reese reported it.
I want to say it was off of 440 maybe somewhere.
It was like near an office park area or something. And she, let's see, it was 2801 Landers Avenue, and I'm not sure where that was. What it was she saw the flames, and it was near an electric substation or something, and she became concerned that it really could cause a problem, and so she called law enforcement, which responded and put the fire out. But she did not see anyone start it. She saw it after it was already in flames. And so, Landers Avenue, I'm not sure exactly where that is.
And there was a video of that. We saw them, we saw the vehicle. We didn't see them, whoever them.
And the charred license plate,
saw
Florida
the charred
plate.
license plate. And then we saw that picture of Mr. Cowan in front. It came from his girlfriend's phone. He was standing behind that vehicle 2 days prior to this incident, and you can see the Florida tag clearly, right there behind him.
Yeah. I think we have a shot live in the courtroom. Let's take a look right now as the attorneys are arriving. There's Jan Norman. Looks like our photographer Bud Nelson is there, leaning over into the jury pool area there, trying to set up our equipment for this. And
Judge Dalton likes Bud.
She does. Bud does a great job. He's out there, and there he is, kind of setting things up, staying off to the side, and the camera, of course, will not show the jury, which is there. The jury's not in right now. There's Jan and Roger. Who do you think will give the closing for the prosecution?
I think they'll split it up.
Split it. So who do you think will go first?
Gosh, I don't know, either Roger or Jan. Roger.
Very different styles.
Very different styles. Jan's going to appeal to the sensibilities, the emotions.
Yes.
Okay. Roger's going to appeal to the law. Not that he can appeal to the emotion, but he's going to appeal to the law because it's kind of different styles.
Yeah, I think Roger goes first. Jan closes.
I think so too.
I think it does, and you hit it right on the head. Roger's a little, and he's definitely not as demonstrative as Jan Norman is. She shows some emotion, and I think that'll be what she uses to close.
Well, and I think you need to poke holes in what they're going to say too. They're going to come back and say, well, we want you to do second degree or facilitation of first, some lesser charge, and then I think in the state summation, whoever does that has to say, well, the jury charge says that, but look at what they're asking you to do. It doesn't. The facts you've heard that come from this witness stand, the evidence, the exhibits, do not fit with the judge's instructions on this lesser included offense.
Yeah, explain to folks why it is that the prosecution always gets final say.
Because the prosecution has the burden of proof. They have to prove each element of the crime beyond a reasonable doubt.
Okay, listen, we need to take a quick break on that. We're going to continue to get everything set up in the courtroom. You won't miss anything once it starts. We expect things to get going at 9, but maybe if it goes before, we'll bring you in. We'll be right back after this. Morning Line. Thanks for joining us. Nick Barris along with Nick Leonardo as we await things starting in the courtroom. We showed you a live picture in there as well, and our crew back in control can show us if something happens, and there they are. The attorneys all pretty much in place, at least on the prosecution side. The two defendants will be coming in just a moment. They may have, before the jury comes in, a possibility of the judge addressing any issues with the court. Maybe they go toward jury instructions if there's any new questions there.
I would think the jury instruction
Pretty much
piece of this is set. I mean, you know, the judge, when she refers to Ms. Franklin, she's talking about her administrative assistant, who, in conjunction with the judge's directions, would be preparing, you know, the jury charge in conjunction with the suggestions by defense counsel and the state. And so I would imagine that any irregularities or anything with the charge or any issues that have already been, at this late date, has probably already been taken care of. There may just be issues about you know, what they can, you know, can they get, how close can they get to the jury box, or maybe some instructions on closing arguments that are unique to Judge Dalton.
All right, I'm just looking at the video screens in front of the prosecution. I was wondering if they were watching our coverage. Do they in breaks?
No, I do think what you will have, I mean, clearly the DA's office is huge. So, I mean, I imagine the DA's office has this on, you know, not for us, but they want to see the trial. We're the last thing they want to see over there. But I would say they probably pay attention to some of the callers too, because they have some good feedback. But
absolutely. We know for a fact in prior trials, judges themselves, sometimes when there's downtime and they're away, they'll watch.
Well, and you know, and you know, Jan Norman, Roger Moore, they're used to this. This is old hat as far as being in videotape. But it's very, very unnerving, and it produces a lot of anxiety when, you know, your boss, Glenn Funk, and everybody in that office is watching you. You know, it certainly is a little bit nerve-wracking.
You bet. They're up on the seal now, so they'll stay there till people come in. Some people are saying on Facebook, is their image blurry? We're looking at the image there. It's not blurry, so that's got to be the signal wherever these folks are watching that they're getting blurry video, because we're looking at the live signal. It looks fine. Let's go to Ed. Ed, good morning. Hi, Ed.
Good morning. Thank you very much for your coverage. I really appreciate it.
Sure.
I have one quick question. During Saturday's proceedings, after Mr. Hills was on the witness stand, what was the purpose and the expense and the whatever for this expert witness from, I believe he was from the Memphis area or West Tennessee? It seemed like to me he didn't accomplish a thing other than he did disagree with the Metro detective who had submitted his report. And I'll hang up and listen.
That would be Eric Warren. Yes, thank you. That would be Eric Warren, who was called, I think, to kind of contradict some of the prosecution witness. I'm trying to find who that was.
And
that
we talked
about the trajectory of the rounds as they were shot into the vehicle, and that would have been Officer Doug Belcher on the bullet trajectory. And I kind of agree with him. I mean, we watched Warren. It's kind of like everything after Hill was anticlimactic, you know?
Well,
and then Warren went on there, and I don't know that he really. Maybe they'll sum it up in the closings. You
know, and I'm tired. I know you're tired. I know the lawyers are tired. But we had talked about this on Saturday, exactly what he was trying to negate by showing, you know, the cones and the trajectory, and that it made. It was negating either premeditation or the intentional aspect.
That's what it's going to, exactly.
We had figured it out. I just forgot what we figured out.
Yeah, but that was it. And I don't remember the exact specifics, but his point was that, you know, showing that maybe the timetable that Belcher provided was not entirely accurate, or not the angles of the bullets, rather, not entirely accurate, to make it seem as though it happened more spontaneously as opposed to premeditation. I don't know how you get that really from bullet trajectory. To me, two cars, 70 miles an hour, parallel to one another, bullet going in the side. Pretty darn clear to me they're side by side. Now, it's hard to say how quickly that happened from the time that they were cut off. See, I think there was premeditation. I think they were cut off, and they said something, you know, along the lines of, let's go get her, and go get him or whoever it was behind the wheel. And they accelerated, got parallel, and pow. Well, 1, 2, 3, 4, 5, 6.
So we'll certainly hear in closing argument from the defense
as
to, you know, what they think they elicited and what that evidence shows and how it benefits the defendants.
Like I said,
you'll hear in closing.
After Devontae.
Well, and the good news is that they didn't leave that day with the last thing those jurors went home with.
That's what you said.
Is a bad taste in their mouth from Mr. Hill. All right? And so, you know, that you did not want to end Saturday and have them thinking about that, because you and I thought about it. We talked yesterday, and it was it made an impression on me, as I think maybe it did you, Mr. Hill's testimony. And so they ended it with something else maybe to think about, and I think that was good for the defense.
I think that's a good point, but until that caller, I had forgotten Warren even testified. I'm sorry, Hill was all I remember from Saturday. Let's go next to Betty. Betty, good morning. Hi, Betty.
Yes, thank you very much. I'll tell you what, you guys are so super, and as always, we, us viewers, we always enjoy listening to you guys. And when it's over, unfortunately, we have to see these things, but we kind of go into withdrawal. I have two questions. Number one, I did not see the beginning, and what is the jewelry made of? And do you by any chance know the median age of that? And the second question is, I have seen her mom and dad, of course, there. And then after listening to this, I saw where the young gentleman, Mr. Hill, had been placed in family services. So is either of these boys, men, their parents there in the courtroom, or any of their family? And I thank you so much, and you guys have a great day. Thank you. I'll listen to you.
Thank you very much, ma'am. While Nick looks to answer your first question, the second one is we've seen family members, and I'm not sure the direct relation to the defendants, or at least one of the defendants on that side of the courtroom. They've been in there. And then, as you said, of course, Caitlyn Kaufman's family and friends are on the other side of the courtroom. And except for some disruption a bit early on, I think where there was some talking maybe during the trial that the judge had to address, I think everyone's abided by the rules and things have gone smoothly with, two different family groups in there.
Talk about things that jurors look at that are not in evidence. If I've had that question from personal members, friends, acquaintances, people I know, Facebook, we've had a few callers, everyone wants to know where are the defendant's moms and dads, right? Okay. And that's something that people are looking for. And it's just those are one of the many things that people focus on that's not in evidence. However, to answer the second part of your question is that it's my understanding, this information came from Nick. He went over there and saw some of these folks, but there are 11 women on the jury, the rest are men, and there are 3 white men, 7 Caucasian females, 4 black females, totaling 11 women. There you go. And it skews older, over 50 or something along those lines, is what they're saying for that. So, yeah, the parents, I guess we had heard about Hill, and that he had actually been living with his grandmother, who, by the way, died in 2018. So there's really no information here about Hill's mother or father, and I don't know much about Cowan's either. There are people in there. I'm just not sure what the relationship is. But think about how interesting that is. We get a lot of people asking that question, and so the jurors are sitting there wondering. And what does it mean, one way or the other, if someone's there and here comes some more into the courtroom, if they have family or they don't? What do you think jurors draw from that? I think it depends on your socialization, from whence you hail, and what your perspectives are. Now, I guarantee you the jurors, and I can understand this, are taking note of how difficult this is for Caitlyn Kaufman's family there. And the mother, of course, we've heard, has been crying in the courtroom, as I can completely understand. The father, at one point, I know on his own, chose to leave the courtroom when they were testifying a bit towards some of her clothing, items of clothing the medical examiner was involved with. I mean, that just has to be horrible. So, I mean, if I was the defense on either one of these, I certainly, one of the first things I would say when I stood up is that, look, folks, we're here because of Caitlyn Kaufman. I would carry that burden. I'd say, this young lady has lost her life, okay? And that is why we were here. So let's not get confused at what the purpose of this is. However, you still have a job to do, and go into why you believe they haven't carried their burden of proof. But I think that the defense could kind of help Hill if they got into that a little bit, to say, this is why we're here. A young lady tragically, senselessly lost her life. But the question is, because they've already admitted to this. So the question is, what crime is it? Do not forget the victim, and we'll touch on that more as we go through this. This trial is about these 2 defendants, and sometimes it gets lost in the mix, but we all know this is about one person only, and that is Caitlyn Kaufman. Let's go next to Crystal. Crystal, good morning. Hi, Crystal.
Hey, so I have a question. Well, first and foremost, I want to say that I drive 440 every day to work, and I pass her cross, and it just absolutely breaks my heart. So, but my question is, do you think, I think it's an open and shut case for Hill, But what are the chances of a hung jury for Cowan?
Okay. You asked that question Saturday when we talked.
I feel exactly the same way. It's a done deal with Hill if it's not something's wrong with that jury. As far as Cowan, maybe. And what if they reach consensus on Hill but don't on Cowan? It can be separated. Hill gets his sentence and goes. And if there was a hung jury, they'd have to do it all over again for Cowan, or he'd plead out?
Yeah, they'd do it all over again, or in all likelihood, if that's how it played out with Cowan. It's up to the district attorney. I mean, they can turn right around and they can impose a sentence on Mr. Hill, and he can go on his way, and then they can pick a brand new trial date before they walk out of the courtroom on Cowan. And that's probably what they would do. But I have, a suspicion that potentially it could very well result in some sort of a plea, potentially.
If it came to that. But if there's a disagreement back there, and that may be one thing that keeps us a little longer during deliberations, they start going down the list, right? And they try to reach a consensus. Remember, all 12 have to be in agreement.
That's right. The verdict has to be unanimous. And so, and I doubt that when they go back there that you have everybody unanimous at first on a count. You're going to have a few folks that say, yeah, I think maybe they're guilty of something, but I don't know that I can go there on both of them with this,
Right, I agree. But I mean, the foreman, by the way, they'll get back there, whoever it is, foreperson that they choose, isn't maybe if that were me, I'd go back. Okay, let's go to each of the defendants. First degree murder for Hill, raise your hand.
That's right. That's what they do.
All the hands go up. Okay, we got that one done. Boy, this is going to save time. And then you're going to go first degree murder for Cowan. Everyone raise their hands. Maybe you get them all. If everyone raises their hands there, what else you got to do?
Go home early. I mean, apparently.
Let's go to Linda. Linda, good morning. Hi, Linda.
Good morning. Thank you for keeping us informed about the law and our justice system. I question Hill's reasoning for downplaying Cowan's role in the shooting. Because he did that, would the gang be more likely to financially support his family after conviction? Thank you again. Bye-bye.
You sure wonder, and that's the point. We just don't know. I did get the sense from him when he talked about protecting his family. They talk about gang members and maybe being family to one another, and that he's trying to protect a fellow gang member here by saying Cowan had nothing to do with it. He said that several times on the stand. He had nothing to do with it. He had nothing to do with it. Well, what did he say? I can't remember. And then he remembered what Cowan said later. So I don't know that he came across as truthful when he was talking about Cowan.
I agree, and it looks like the judge is coming in, so let's see if we're going to go ahead and pick up with closing arguments.
Here we go.
Okay, let me address the matter of, let's see, where's my docket? Mr. Goodner, Mr. Coleman, and Mr. Whiteside. I got some late, I thought we addressed all pretrial motions.
Your Honor, what happened was that we had gone and done an open documents meeting with the general on, what month are we in? And at that point in time, we let him know that we did not have a final witness list, and there were other things that we were missing. We didn't get that witness list until Friday. We also didn't get the final report or the CV for one of the experts until Friday. The final report that we didn't receive until Friday was the cell phone dumpage and everything that they were planning to use. So that is the reason for all of the motions that you got, or most of the motions that you got. And as I want to note to Your Honor, we did do our motions in limine back in October, I think of 21 at this point in time. And at that point in time, the general who was on the case told us that he had given us all of the discovery. I have it in my notes. So we are just doing our due diligence, which is why you got the motions that you got.
Yeah, if I can respond to that, Judge. What they're talking about as far as the phone dump was all provided months and months and months ago. It appears to me that they just did
what we're seeing here is every Monday we have several trials that are set here in Davidson County, and so clearly Judge Dalton has another trial which is set today that involves these individuals, and so she's just taking up some issues right now before they resume. Again, these judges are very, very busy, but we have, District Attorney General Vince Wyatt, who was just speaking on behalf of the state, and oddly enough, that picture there, that's on the wall, that's of his father. His father was Judge Randall.
Sure, I remember him. Right. Yes. So just to be clear, then, what we're hearing here has absolutely nothing to do about the Caitlyn Kaufman case, but they have to address these other issues for things happening in the court.
That's right.
Okay, just to let you know so it doesn't confuse folks.
Early for the other docket. I just wanted to go ahead and address that matter since I have that set for trial, and we'll likely, I don't know what we're going to do with it. I guess we'll see at 1 o'clock. But as it relates to Mr. Cowan and Mr. Hill, are we ready for them to come out?
Yes.
Go ahead. Have them brought out, please. Okay. All right. Let's see. I believe on Saturday, the defense, Mr. Hill closed his proof, and Mr. Muckable, there was no proof on behalf of Mr. Cowan. Is the state gonna call rebuttal proof?
No, Your Honor.
Okay, so are we ready with closing arguments?
Yes, Your Honor.
There are two, well, not two, one. Related to the jury charge, I noticed this yesterday in reviewing the instructions, and we would request, because Mr. Hill is not alleged to have facilitated anything, the proof is pretty clear that the state's position is he's the shooter. So I think that's a bit confusing.
What page are you looking at?
This may be not the
Well,
most
yeah,
updated
that's
version, but 7 or 8. It starts right behind second, is where facilitation is thrown in there.
Okay.
And that clearly does not apply to Mr. Hill. And so it, from my perspective, it's a little bit confusing, and I would just ask the court to either type in there that this particular charge has no application to Mr. Hill, because I think it could be confusing, and that they can disregard that. All of the proof centered around, from the state's perspective, even from the state's own perspective, that there's no evidence that Mr. Hill was a facilitator of anything, and that could only apply to Mr. Cowan.
Okay. Does the state care to be heard?
The state would submit that the law requires anytime pretty much that there's more than one defendant that facilitation be given as a lesser included offense. And for that matter, it would be within the jury's prerogative at this point for them to find that Mr. Cowan was the shooter. We will not know that because they don't have to specify that in their verdict. So I think that the law would require that to be a lesser as to both defendants. Because otherwise the court would be going down the path of, I would submit, commenting upon the facts.
Yeah.
I don't believe any rational trier of fact who sat here for 5 days would ever think that the state's position was that Mr. Hill facilitated anything whatsoever. And they have been very clear with the presentation of their case that if there's a facilitator, it would be Mr. Cowan. And so I do think it's inappropriate to not advise the jury that this instruction just simply does not apply to Mr. Hill.
I think that is something that is probably more appropriate to be addressed in argument. I think that if I agree with the state that if I address it in the charge, it'll be me commenting on the proof, and I'm not supposed to do that. But I think it's something that can most definitely reasonably be addressed in the closing arguments.
Understood.
But your objection or suggestion is noted for the record.
Yes, ma'am.
Okay. Is there anything else? Is everybody here? I think they said that all of the 14 members of the jury are here.
Judge, I'm going to be using a PowerPoint for my closing argument. I don't know if, since we don't have a witness, if the court wants that to remain there, or if you want to reposition it. It matters not to you.
Well, reposition. I just don't want it to block my view of the jury, but they have those there. And I guess they could turn it. Versus she's using PowerPoint for her closing arguments. Maybe we'll get that.
Just pull it out.
you could just reposition this large monitor, but don't put it in front because it'll block my view of the jury. Just kind of put it in front of the witness stand, I suppose.
All right, Jan Norman is talking about how she would like to do her closing argument. She would like to use PowerPoint, and it's important to point out that the jurors have little screens there right in front of them so where they could follow along. And they had a brief discussion about whether or not Mr. Hill should be charged with, in the jury instructions, with facilitation of first-degree murder, and clearly the proof doesn't support that because he is the primary actor. However, General Moore is correct that if the judge were to take that out, then she would be commenting on the evidence, and that the jury could indeed decide that discredit Mr. Hill's testimony and decide that Mr. Cowan was the shooter. So again, they've noted that objection for the record, and it looks like that the jury charge is going to remain as it is, and now they're going to bring the jurors in and begin with closing arguments.
Yep. Video monitor set up.
Computer's not coming up. There we go.
All right.
Okay, we all be seated. Let the record reflect that all of the members of the jury hearing the trial of the state of Tennessee versus James Cowan and Devontae Hill are present in the courtroom on Monday, January 30th of 2023. And I hope everybody was able to rest at least one day, a day and a half. Thank y'all for coming in and giving us your time. We're gonna go ahead and proceed with our trial this morning. Okay, I believe that on Saturday, counsel from Mr. Hill closed your proof. Is that accurate? Yes, ma'am. And then Mr. Munkabo, no proof on behalf of Mr. Cowan?
Yes, Your Honor.
Is there any rebuttal proof on behalf of the state?
No, Your Honor.
Okay. Are we ready to proceed with closing arguments?
Yes, Your Honor.
Is the defense ready to proceed?
Yes, Your Honor.
Ladies and gentlemen, if you recall, back when we started this process, I explained to you that that the parties, if they wish to proceed doing so, have an opportunity to present you with a closing argument. Now, comments from the attorneys and their arguments are not to be considered by you as evidence in the case, but it's pretty much to provide a guide to you of the evidence that has been presented. It is their perspective of the evidence that has been presented. As I have stated, the evidence for you to consider is through witness testimony from the witness stand, okay? All right.
Thank you, Your Honor.
Ladies and gentlemen, this case is about Caitlyn Kaufman, the 26-year-old nurse who was driving from her apartment in Lebanon, Tennessee to her job at St. Thomas West. This case is about Caitlyn Kaufman. It's about her murder. She was driving to work, talking to her mom on the phone like she did every day. Every day. She is just driving to work when two men who are strangers to her, strangers, people she doesn't know at all, they both decided to gun her down because she cut them off. They knew it was her. It was a specific vehicle. It wasn't a random vehicle. It wasn't a random shooting. It wasn't just shooting out the window and, oh, goodness gracious, there was a car there. No, they went after Caitlyn. Caitlyn Kaufman, she was targeted by those two men on December 3rd, 2020. They did it on purpose. They had a reason, a motive to murder her. And it took both of them. It took both of them to shoot at her and kill her that day. It is not possible for Devontae Hill to have done this alone. That is not possible. It took both of them. And they murdered her knowing they were going after her, the girl that cut them off. 6:08:41 p.m. This time is very important in this case. That is the moment that Caitlyn Kaufman's speed slowed. That is the moment that she begins to slow, and 18 seconds later at 6:08:59, her car stops moving, she stops moving, she never moves again. She stops breathing. Dr. Carney testified that she would have only been able to live for seconds to a minute. That is the time that she is shot based on the evidence presented to you in this case. And that time is very important. At the beginning of this process, we talked a lot in jury selection about the law that Judge Dalton will be giving you after closing arguments. The law is very clear. It is not ambiguous in any way. You must begin with the indicted offense. You must begin with it. I would assume that when defense counsel gives their argument, they will be talking about something other than this indicted offense. But the law is clear. You must begin with the indicted offense, which is first-degree premeditated murder. And it's not unless and until all 12 of you would say, no, the state has not met their burden, they have not proven that beyond a reasonable doubt, that you ever begin to consider the lesser included offenses. Now, when you get the verdict form, it has a bunch of them listed. It begins with first-degree premeditated murder, it says or, and it has the others. But you do not consider them unless all 12 of you would decide that the state had not met our burden. Count one is the first-degree premeditated murder of Caitlyn Kaufman. And again, we talked about these elements that the state is required to prove. It's that the defendant for whom a defendant is criminally responsible, which we talked about that at length in jury selection, unlawfully killed the alleged victim. Because it's not just the principal, it's also the other person that is criminally responsible for them. If they aid, attempt to aid, solicit, direct, they are also responsible for first-degree premeditated murder. It requires that the defendant act intentionally And a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. I submit to you that this was a targeted murder. It was very specific about the girl who cut them off, and that the killing was premeditated. We talked about premeditation in jury selection. A premeditated act is defined under the law as one that is done after reflection and judgment. It is an intent that must be formed, but it can happen in an instant. There is no specific amount of time, and we talked about that concept of when you get to that yellow light, and are you gonna slam on the brakes or are you gonna hit the gas and go right through it? It's that quick that you can make that assessment. That reflection and judgment has no specific time. No specific time at all. And it can happen very quickly. It just means that you decided to do something and you decided. You had that thought and you decided to do it. We don't have one shot in this case, not 2 shots, not 3 shots. We have a minimum of 6. Minimum. Up to 17. But a minimum of 6 shots directed directly at Caitlyn Kaufman. Now, when you get the jury instruction, this definition of premeditation is lengthy, and it does address whether or not the person is sufficiently free from excitement and passion. And when you talk about excitement and passion as it relates to premeditation, that relates back to one of those lesser included offenses. A lesser included offense that you do not consider until you have determined that premeditation does not exist. That passion and excitement requires adequate provocation by the victim. It requires that Caitlyn Kaufman did something to deserve to be shot and killed. I submit to you the evidence in this case, you do not have any of that. She cut them off. Mr. Hill's testimony on Saturday was that he didn't even think she saw them. He doesn't think that was even intentional by her. But cutting someone off is not adequate provocation ever, no matter what the circumstances were. So when you're reading this definition, keep in mind, any situation, there is going to be some amount of excitement. When you are firing a gun over and over and over and over and over again at someone, that does not prevent you from having the reflection and judgment to decide to pull that trigger every time. You decide to pull the trigger again and again and again and again and again. I want to talk first about the shooter. We have a shooter and a driver. It took both of them. Mr. Hill has admitted to you that he is the shooter. He has admitted that to you and said that he did it. Before this week, he also admitted it to Jaquez Merrill Odom, his childhood friend. He told Gucci that he effed up, that he did this. And he was very specific that he said that they were on the interstate and a car that had got on the interstate almost wrecked into them. He was very specific about that statement. That was what he testified to in the trial this week, and he even specifically said that it was at the point that they were merging. The car was getting on the interstate. It was at the point that they were merging. I want to go over the factors related to premeditation because, again, Mr. Hill has admitted to you that he is the front seat passenger, he is the shooter. He shot all of those rounds at Caitlyn Kaufman, and he did this. And when you're considering premeditation, there are specific factors that you can consider, and one of those is that he chose to use a deadly weapon. The deadly weapon that he chose to use in this case is that Springfield XD 9mm handgun. That was the gun that Devontae Hill armed himself with. He left the house with that gun. He had that gun on his person. That magazine has a 16-round capacity. You heard testimony that the firearm itself has a total 17-round capacity. Devontae Hill testified that it was already racked and ready to fire. He armed himself with that weapon. And there are at least 6 shots fired. At least 6 shots that are fired directly at Caitlyn Kaufman. Devontae Hill's testimony was that when he got into the car, he put that gun on his lap. He wasn't holding it in his hand. He said several times he had to pick it up. He had to pick it up. He picked the gun up, and at that point, he's gonna have to roll down the window, but he is deciding to fire that gun at least 6 times. At least 6 times. He said he did not remember how many times he fired the gun at her, and he didn't remember how many bullets he had in there. But it's at least 6. He is pulling that trigger over and over and over again. Every time he makes a decision, if it was just that time period, that in and of itself is premeditation. But he has to be up on the car to even begin firing at her. They're not shots into the back of the car. Now maybe those are ones that missed, because he doesn't know how many times he fired at her. But that's a decision that he is making every single time. Even after that one round goes directly into her driver window, we still have that 6th round in the front. He keeps firing at her over and over and over again. Which I want to talk about that window, because before you can fire all those rounds, the window has to be down. Now, he made a comment during his testimony that they had let the window down to let the smoke out. He didn't say exactly when that occurred. He didn't describe how they let the window down, if it was just a little bit to let smoke out, or if it was all the way down. But that window has to be down for him to be able to do this. Now, when he was interviewed by Detective Dickerson, in that interview that was submitted to you as evidence, when he is lying to Detective Dickerson, claiming to be the driver, when he has named Raquan Evans, who he claims is a random name, but it is a person who matched the description, is an actual person, when he is saying that Raquan Evans did this, he tells the detective that he looks over and he saw him rolling the window down before he started shooting. Not when he's up here telling you that he's the shooter, but when he's first asked about this and he's lying to Detective Dickerson, but he's having to pretend to be the driver, and he's talking about what he sees the shooter do, even at that moment, he has the shooter having to let the window down. But even then, you were also submitted with a jail call, which the audio is not the best quality. It is very hard to hear. But in that first jail call, this is number 1, you can skip ahead to the 12 minutes and 45 seconds. In that call, he's talking to his family. He's just been arrested and charged with this crime. If you remember, this is the point where we have multiple females on the call because they've made a 3-way call. And they're asking him about what happened. Now, at the beginning of the call, He did not want to say who was driving and who was the passenger. He's not telling his own family, I was just driving. He's also not saying, I'm the shooter. He doesn't want to say either. He says, we were driving, and doesn't want to tell them. This is right after the arrest. He's just described the same thing to Detective Dickerson. He's talking to his family, and he says the window had to be let down. When you're thinking about those moments of premeditation, which I submit to you that the premeditation begins well before that, and we'll get to that, but just in the moments of the shooting itself, he said that he picked up the gun. He had to pick it up. He made that decision. He knew he was shooting at the girl who cut them off. He also told you that Mr. Cowan had smashed the brakes, smashed on the brakes. Now, nothing was said about what happened to the gun when he smashed on the brakes, but Mr. Hill testified that it startled him. So I don't know if he's picking up the gun from his lap, if he's picking it up from the floorboard, but he has to pick it up, and he's doing this before they're even on top of her. Again, I submit to you that the premeditation in this case, it is extensive. 6 shots, but they are all aimed. They are directed directly at Caitlyn Kaufman's vehicle. That is an aim and shoot again and again, and keep shooting even though you've seen that you've hit her, even though that you've seen it. You can also consider the fact that Caitlyn Kaufman was completely unarmed. You know that she's unarmed. She's sitting there driving in her car. And you saw that picture of that injury to her left arm, that bullet that went directly into her arm. And I'm not going to show that image to you again, but it lines up with somebody that's driving. He would have to be right on top of her to do that, seen her. He fired directly into her driver window, and he kept firing, kept aiming at her driver window after that bullet went through, the one that struck and killed her. You can also consider the failure to render aid to the victim. No one called 911. No one stopped. Devontae Hill didn't call anyone. He didn't stop. James Cowan, who Devontae Hill claims knew nothing of this, he didn't stop. He didn't try to help her. You heard from Detective Dickerson, they didn't get calls that anyone saw this. There's no eyewitness. They were the only ones that knew what they did to her. And I submit to you that Mr. Hill's testimony, he actually made a comment that afterwards they had to sit and marinate on it. He also claims at that point he didn't know that he had killed her, but him and Cowan have to sit and marinate on it. I submit to you that Mr. Hill that fired those shots directly into that car, he knew exactly what he had done. They're marinating on, we just shot and killed someone. That's what they're marinating on. Evidence of motive. Again, we've gone over this, he gave a very clear motive. She cut them off. He targeted her because he was mad, which she cut James Cowan off. He's the driver. He's the one that smashes the brakes. Mr. Hill said that he didn't say a word, not one word, didn't say anything. But Mr. Hill is so upset, he wants to gun her down. That is a motive. The state doesn't have to prove motive, but there is one. He told Mr. Merrill Odom that he did it because she almost wrecked into them when she got on the interstate. Mr. Cowan's comment that Mr. Merrill Odom heard after they know that they have not only killed a person, the girl in the SUV, but they know that it's Caitlyn Kaufman, the nurse from St. Thomas West. They know exactly who they've murdered. And Mr. Cowan, who Mr. Hill wants you to believe had nothing to do with it, his cousin, his friend, his 9/8 Mafia gang brother, his comment was she shouldn't have did that shit. It is what it is. F it. That's his comment about them, both of them, because it took both of them murdering Caitlyn Kaufman. You can also consider destruction of evidence of the killing and any calmness after the killing, which the next pieces of evidence that I want to go over, it combines both of these. These are two separate considerations, but they kind of go hand in hand in this case. You have Mr. Hill's text messages immediately after he's fixing to go back to Panorama Apartments, hanging out. You also have his internet history. Before he searches Nashville shooting at 7:22, he says that he's just cooling in the house. Not telling anyone, he's stressed out, he's just cooling in the house. And he searches Nashville shooting an hour and a half before Officer Brian Thompson even discovers Caitlyn Kaufman. He's already searching for it. And no one other than the two men responsible for it know that Caitlyn Kaufman is dead. And he is already searching for it. Which his comment was immediately after they marinated on it for a minute. You have more history where he's ordering pizza that night. He still doesn't have anything about the news article that indicates that he is aware that Caitlyn Kaufman is dead. But again, the time frame, police officers aren't even getting there until 9 o'clock. But he already wants to get rid of the XD9. And it's very specific when he is messaging Zone God Wax that he says, trade me something. Trade me. Not let me sell you, let me give you, get rid of this. He wants to trade. That's at 1:16 a.m. But also, he's messaging, asking who's got some 9 shells. I submit to you, we talked about direct and circumstantial evidence and how the law considers them the same. This is circumstantial evidence that he fired every bullet he had at Caitlyn Kaufman. He doesn't ask one person, he asks 2 people. Where can he get some 9 shells? Now, Jacqueline Merrill Odom testified that he unloaded that gun when he took it up to the hospital because his plan was to give it to Caitlyn's mother. And the officers that responded, Officer Rosenfeld said that when he got there, he found the gun. I will say, glove compartment, center console, can't explain that. He knew that he had put it in the glove compartment, which he believed was the center console. That's where the bullets were. Who knows if it didn't fit, how that worked. He had them separated. But that gun was unloaded, and there were 13 9mm shell casings, cartridge casings, in the center console. He calls them shells. Our witnesses refer to them as cartridges. You also have where he is searching the news, and again, searching, looking for this story. It's not until 2:22 that he sees that news story. And right after, at 2:42, again, he's just cooling in the house, listening to some music. He's read the news story. It doesn't say they have any suspects. Calmness after the killing. There was no evidence presented to you of anything but calmness. Now, Mr. Hill said that he was having a hard time coping with it. But December 5th, 2 days later, you have the messages that they're turning it up for Duty's birthday. Now, Duty's birthday was on December 1st, days before. They have this planned birthday party celebration. We have multiple messages that they're going to turn it up for Duty's birthday party. And then you have still images from a video taken on Demonisha Carter's phone, the woman who is Duty, who is his cousin, who is his family, who is his blood, who he would protect over anything. She is his girlfriend. She took this video. And Mr. Hill's testimony to you is that he's never spoken to her. He did not speak to her when they picked her up immediately after the shooting. He had not spoken to her. But she took this video of them celebrating, having fun at a birthday party for Duty. Mr. Cowan, who is the driver, he knows what's happened. It's all over the news. The news is posting, please call Crime Stoppers, there's reward money. Mr. Cowan knows what happened to Caitlyn Kaufman. And Mr. Hill and Mr. Cowan are there celebrating Duty. Duty's 28th birthday. You can also consider the destruction of evidence of the killing. We have multiple things that were evidentiary that were destroyed related to Caitlyn Kaufman's murder, but we have some things that they just attempted to get rid of. December 6, 2020, Jacquez Merrill Odom said that it happened that Sunday. It doesn't actually matter what day it happened, but he said it happened on Sunday. That he traded Mr. Hill his M&P .40 caliber handgun for the Springfield XD9. He said he traded him for it on that Sunday, and it wasn't until after they traded he told him what he did with the Springfield XD9. Mr. Merrill Odom testified that he tried to get him to undo it, but he wouldn't. That same Smith & Wesson .40 caliber handgun that they traded was found with Mr. Hill when he was arrested. They were able to corroborate that. But Mr. Merrill Odom has the murder weapon. He was supposed to have gotten rid of it, and he didn't. But Mr. Hill tried to get rid of it. He may have messed up offering to trade it versus just saying, hey, get rid of this for me. But he tried to make that murder weapon go away so that we would never be able to test the casings at the scene to anything. Which again, he traded it.
Hey, man, I walk away, fool. My goddamn uncle bullshit. I said, walk away, my uncle bullshit. Yeah, walk away, nigga. I'm trying to talk to you by yourself. Man, bro, tell this nigga that I was not in the car with your ass whenever that shit happened to that nurse Caitlyn. Come on now. And then tell this nigga that goddamn that I traded you to MMP for, bro. Nah, nigga, I already know, fool. That's all I want to know, fool. I love you, though, bro.
Which there is also a jail call where Mr. Hill specifically references that he swapped the Springfield XD9 with Jacquez Merrill Odom for the MMP 40. When Mr. Hill was testifying on Saturday, he didn't want to agree that he had swapped the gun, that he traded it. I have no explanation of why. You might consider that Mr. Cowan might have been upset to know that he gave it to Jacquez Merrill Odom, who wasn't one of their friends, wasn't someone that Mr. Cowan would trust, but Mr. Hill gave that gun to Jacquez Merrill Odom, and that is how they got caught. But he tried to get rid of that evidence. The December 11th interview with Detective Dickerson, Mr. Hill named Raquan Evans as the person who killed Caitlyn Kaufman. They brought him a picture. He confirmed that it was him.
That's definitely right one. You know what I'm saying? You've never seen it before in your life? No.
But when they showed him Mr. Cowan's picture, he said he didn't know him at all, never seen him in his life. Now, in those jail calls that you listened to, the beginning of the calls, Mr. Hill keeps talking about that MMP 40 that they got out of the house because he can't figure out why the news has said that they have a ballistics match. That doesn't make sense to him because he's like, that gun's not it. I know that's not it because he knows it's the Springfield XD9, which he had told Jacquez to get rid of. He doesn't realize that they have that gun at all. He keeps saying that MMP 40, it's not it, it's not it. That is said over and over again. But yet he still knows for sure in that very first call, he knows that it was Gucci that snitched on him. He knows it's him specifically, that it's Jacquez who snitched on him because they know about James Cowan. They had his picture, they have his phone number, Mr. Hill's phone number, and they know about the Cadillac. So Mr. Cowan, they have that information. They know about the Cadillac. They have Mr. Hill's phone number because they had his location, which at first he thinks, oh, Duty's going to be fine because Jaquez doesn't have Duty's number. Jaquez couldn't have given that number to the police like he gave them mine. But then Big Cuz tells them, but they got your phone. And then Hill knows, I've got Duty's number saved in my phone. It's under Duty. So then immediately the plan goes into place where he is trying to get rid of more evidence. Which, like I said, when you listen to those calls, he doesn't realize yet that Jaquez kept that gun and the police have that gun. He thinks they just have that MMP-40. So he's clicking through the information he knows they have so he can try to get rid of anything else that would connect either of them. And he is telling Big Cuz on the calls that Cowan needs to get a new phone. Special Agent Andy Valley testified that the phone records showed that after those calls, within just a couple of hours, that's exactly what happened. He stopped using the 615-477-8664 number, the number where his phone is tracking Caitlyn Kaufman for 10 minutes on the interstate. That phone was never recovered. We don't have any messages from that phone. We don't have any pictures from that phone. We do have the carrier records, and the carrier records put James Cowan there. But he switches phones after Hill calls Big Cuz and tells him to. Now, Mr. Hill's testimony to you, sworn testimony on Saturday, was that Cowan had nothing to do with it. Not one iota of responsibility. He did nothing. But yet, not only does Mr. Hill think that Mr. Cowan needs to get rid of his phone and get a new phone, Mr. Cowan agrees with him and switches phones. Again, you have the calls from booking where they're talking, he knows that it's Jaquez because they are asking all these questions about Duty. And he knows about the car. So not only is he telling Big Cuz specifically that he needs to get a new phone, but he keeps telling Big Cuz about the silver Cadillac. They know about the silver Cadillac. Now, I believe his testimony on Saturday was he didn't tell Big Cuz to do anything about that Cadillac. That whatever Big Cuz did with that information was what he did. That was his responsibility. That was on Big Cuz. But we know that that Cadillac ends up being burned to the ground. It just so happens, Mr. Cowan, Detective Gish testified that that first car, that he believed that that was the same car parked at the Oriole Drive address, which was Miss Demonisha Carter's sister's house. It was parked there with that same Impala that Mr. Cowan was arrested in. The one that was rented to the same fake account of Hertz that the Cadillac was rented to. After that car pulls up, you actually can see a person that gets out and walks around the Cadillac. Now, Karen Reese described this vehicle fire to you. She described that it startled her because she first heard an explosion. And then it was explosion after explosion. Which you saw the photographs of that vehicle in the aftermath, because Karen Reese, not only did she see the vehicle on fire, but she called 911, she reported it, and she waited until after the fire department had put the fire out and the smoldering had subsided, and she went and took those photographs of that vehicle. They were trying to get rid of any evidence that connected them to the shooting of Caitlyn Kaufman. They thought they had gotten rid of the gun. Now, Mr. Hill, because Gucci had snitched on him, they had his phone number, but he didn't want them to get Cowan's information. He told Big Cuz he needed to get a new phone. Now, Mr. Hill did not burn this vehicle down, but he definitely wanted Big Cuz to have that information. Mr. Cowan is the owner and driver of that Cadillac. That was the evidence that was presented to you during the trial in this case. He is the driver. It definitely took both of them. He was the one that was doing stuff that day. They're going out to Hermitage. It's Mr. Cowan that takes Mr. Hill out to Hermitage. They're out there for less than an hour, and they have to go back to pick up Miss Carter from work. She sends them the address, and they are going to pick her up from work. He messages her at 6:20 p.m. This is 12 minutes after Caitlyn Kaufman has been murdered. Just says, I'm at the light, I'm outside. Like nothing had even happened. Now, all three of them, Agent Valley was able to tell you he had cell phone records for all three of them at that point where they picked Miss Carter up from her job. I submit to you that the evidence that you've heard in the trial this week, there are two incidents. Two separate and distinct incidents that have been described. The first is that Caitlyn Kaufman swerves and cuts them off. Mr. Hill has said that many times. She was also shot and killed, 6:08:41. We know that. But the incident related to when she swerves and cuts them off, Jacqueline Merrill Odom specifically testified that when Hill told him that he said that it happened when she got on the interstate. He said she was merging. Mr. Hill has always maintained that she cut in front of them. That's been very specific. We know 6:08:41 is the time she shot. Now, Special Agent Valley, he gave a very detailed description of what he was able to tell from the carrier records, and that that Mr. Cowan would have to be in that arc. And we know exactly where Caitlyn Kaufman's device is. It was logging every single second, her GPS lat long. Now, when Mr. Hill testified on Saturday, his attorney asked him a very specific question, and he prefaced it because this is the most important point. What happened? Mr. Hill's response was, while we was riding, I can't say, but I know that she came from the left of us because we had just got on the interstate. She came from the left and she cut us off, and when we hit the brakes. Now, I submit to you that when they came on the interstate, the other evidence in this case doesn't support that. His attorneys went back and asked him a follow-up question of saying specifically, I thought when I asked you the first time that you said you had just gotten on the interstate. And Mr. Hill responded, and he said, like when we got on the interstate, we rolled for a while, and then somehow the car just came from the left of us, and we smashed on the brakes. This is the next point that Agent Valley showed. This is at 5:58 p.m. Now, Caitlyn Kaufman's device is in that arc of James Cowan's carrier records. It's in the same point. They weren't together before, but now they are. This is a straightaway at 5:58 p.m. Caitlyn Kaufman was on the phone with her mom, and that call was 14 minutes and 15 seconds. It's at 5:59 when Caitlyn hangs up from her mom, Diane. She's not on the phone anymore. There's no one for her to say anything to about what's happening around her. At 6:01 p.m., again, we have them in the same spot, but they're on a straightaway. It's at 6:02 p.m. that we have the first place on this path, this route that they are taking, Caitlyn Kaufman's drive to work. This is the first point where we have a merge point. Special Agent Valley testified and told you he was very familiar with that route, and he had actually driven it in reference to this case, and he said at that point there are multiple lanes that are merging. But at 6:03 p.m., the merge from I-24 to I-440, that is when it goes down to one lane. That is when it goes down to one lane, and it might be described as she is getting on the interstate. You all know that she got on the interstate well before because she's driving from Lebanon. That is the point that she would be merging. She would get on the interstate. There's only one lane, and she could cut them off. I asked Mr. Hill questions about what point this swerving, this cutting off happened. And I specifically said, what point on your route? And he said, no, I couldn't tell you specifically. No, I'm pretty sure it definitely didn't happen as soon as we got on. And I asked him, okay, so it happened sometime on your trip. And he said yes. At no point on Saturday did Devontae Hill testify, oh, she just came over from that left lane right there on I-440 right before I shot and killed her and right before we got off the exit. There is a beginning to their trip that starts in Hermitage, and then the ending when they get off at West End Avenue. Those are the 2 points of reference. Mr. Hill not once said that it happened on I-440 close to where she was shot. Now, he describes the shooting as happening in an instant. It happened very quickly. But he was also very specific, even when talking to Jaquez Merrill Odom, not knowing that this would ever be presented to a jury, that it was when she got on the interstate, when she was merging. That's when she swerved and cut them off. 5 minutes before she is shot and killed. Mr. Hill said that Mr. Cowan smashed on the brakes. He smashed on them. I asked him if that was a hard stop, and he said, yeah. Now, at that point, he said she's in front of them because he testified that he didn't think that she knew she did that. She's in front of them. Now they have to catch up to her. They have to catch up to her, but they also have to pass her. We have 4 minutes. 4 minutes where we don't have any carrier data from Mr. Cowan's device. 4 minutes before the next point. If she has already swerved and cut them off, they are driving at the same pace. They are going after her. Mr. Hill testified that there was traffic, but there was no one who called the police and said that they saw those two cars, that they saw a shooting. I submit to you that the evidence indicates they were going after her and following her, potentially waiting for her to be alone. But that this went on for minutes. At 6:07, they are right there on top of her. She is not shot until sometime close to 6:08:41. We have 6:08:13. Again, they're still on top of her. 6:08:42. We have where the crime scene began, where the crime scene ended. Caitlyn is not at her exit. There's no merge point. There's no way for her to be getting on the interstate at that moment that she's shot. Now, it doesn't matter what point she swerved. It honestly doesn't matter if she never did that. But the testimony and evidence that was presented to you during the trial this week, which includes Mr. Hill's testimony, is that it happened when she cut in front of them. And he was very specific that she came from the left. Cut in front of them, she was in front of them. The driver, Mr. James Cowan, the driver whose comment after is that she shouldn't have done that shit. She shouldn't have cut them off. Criminal responsibility for the conduct of another. We talked about this definition. You have to know what the other person's doing. You can't be completely unaware. I submit to you that the facts and evidence in this case, it is impossible for Mr. Cowan to have not been aware of what Mr. Hill was doing. He is riding in his car with a loaded gun on his lap. Mr. Cowan can see that. It's right there. But again, the window has to be let down. And there are a minimum of 6 rounds fired from his vehicle. Mr. Cowan has to aid or attempt to aid Mr. Hill for any of this to ever happen. Encouragement of the principle is sufficient. You don't even have to be present to find someone criminally responsible for the conduct of another. I submit to you that the evidence and testimony that you have heard is that James Cowan, number one, had to speed that vehicle up to get to Caitlyn Kaufman, but then he has to drive around her. And he has to maintain a speed when both vehicles are going over 70 miles an hour. He has to maintain a speed to allow Mr. Hill to shoot all 6 shots that hit her vehicle. And he doesn't know how many he fired. There could be more that missed, but he was able to maintain the Cadillac's position so that he could fire 6 rounds at minimum directly into her vehicle. He maintained speed so that he could shoot the one that goes directly in her driver window. Mr. Cowan and their expert, a defense expert called by Mr. Hill's attorneys, he testified that the vehicle that would have fired, those shots would have been fired from would have had to maintain a speed, and that the shot pattern that he analyzed, there was nothing about it that indicated any erratic or quick movements by the driver of the Cadillac. There was nothing that indicated that there was a hard left swerve. There was nothing that indicated that anyone slammed on the brakes. We have at least 6 shots fired. Mr. Hill's testimony is that Mr. Cowan is completely unaware. He has not said a word. He has no idea what he's doing. If that were true, one would expect that there might be some evidence that Mr. Cowan slammed on the brakes when that first gunshot goes off, if he has no idea what they're doing. But the evidence is that Mr. Cowan kept that vehicle, that he pulled up on Caitlyn Kaufman. Mr. Cowan had the power and control to allow this shooting to occur or to stop it. Mr. Cowan is the person that could have stopped this from happening. He assisted Mr. Hill. He aided him. It is illogical that he would not have known what he was doing, but the physical evidence and the testimony of all the expert witnesses and everyone that you heard from this week is that Mr. Cowan was maintaining a specific speed. Now, he might have been pulling up and then slowing down to go back and pulling up and slowing down to go back, but he did not make any movement that would have stopped the shooting from happening. There are no shots into the back of the vehicle that indicate that he slammed on his brakes. Mr. Hill is able to keep shooting at her even after he's hit her. But there are 6 bullets that strike her vehicle. That fatal bullet that hit Caitlyn Kaufman in her arm, that struck both of her lungs, her heart, that ended her life. They both did that, Mr. Hill and Mr. Cowan. It took both of them, not one of them. It took both of them, and they did it for a reason. They had a motive. Mr. Hill wanted vengeance against her for cutting off Mr. Cowan. They picked her, they targeted her. She was fired upon multiple times on purpose. They were driving over 70 miles an hour. That takes both of them. They both did this, a driver and a shooter. I submit to you that the evidence in this case supports a verdict that they are both guilty of first-degree premeditated murder. Mr. Hill admits to being the one that fires the shots. If their spots are reversed, it does not matter. The driver and the shooter are both responsible because it took both of them. Mr. Cowan is criminally responsible for Mr. Hill because he assisted him. He knew what he was doing and he helped him. And I ask that you return a verdict that James Cowan and Devontae Hill are guilty of first-degree murder for the murder of Caitlyn Kaufman. The nurse that was driving to work when she was gunned down and died sitting there on the side of I-440 at 6:09 p.m. on December 3rd, 2020, sitting there with her foot on the brake after her heart had been severed by a bullet. She died on the side of the interstate because of both of these men. Both of them. Thank you.
Good morning, ladies and gentlemen. Mr. Cowan did not kill Miss Kaufman, nor is he criminally responsible for anyone who did. On Wednesday, I told you about the proof that you would not hear in this trial. You heard no proof that James Cowan killed anyone, no proof that he caused or otherwise intended the death of anyone. You heard no proof that he had a weapon, fired a weapon, or gave a weapon to anyone. You heard no proof, and this is perhaps the most important missing evidence during this trial, no proof that he solicited, ordered, directed, commanded, or helped anybody to kill anyone. In fact, you heard no proof that Mr. Cowan knew anybody was going to be killed. So what have we heard during this trial? Well, one of the state's main witnesses, cooperating witness, Jaquez Marilodum, had his own issues that we all heard, but he admitted that he was a friend of Mr. Hill's, and he was standing in a courtyard, and Mr. Hill approached him in a panic. And I think the words he said were a nervous panic. He went up to him and said, hold this up in a panic, says, oh my God, look what I did. I effed up. I did this. Not what we did, what I did. We also heard from Devontae Hill, who came here, stuck his hand up and swore to tell the truth, and he did, ladies and gentlemen. He admitted shooting Miss Kaufman. He also said that James Cowan was driving the vehicle when he did it. Both of those things were true. I asked him, and he testified truthfully, that he was doing drugs that morning. He was high on cocaine, pills, and weed at the time which this unfortunate incident happened, due to his reckless conduct. He further testified that this happened in an instant. Cars swerved over like this. Things happened in an instant. He did further testify that James Cowan, and you heard him, had no idea that he was going to shoot at Miss Kaufman's car. He further said that this all happened in such an instant that Mr. Cowan had no time to react before that fatal shot was fired. You have heard no evidence to contradict Mr. Hill's testimony about James Cowan's lack of involvement in this. Undoubtedly, this is a tragedy, ladies and gentlemen. It's a tragedy, and no family deserves this. You might have noticed that I did not have questions for many witnesses during this trial. And that was simply because very few witnesses had anything to say about Mr. Cowan. If the state had more evidence linking Mr. Cowan to this crime, rest assured, ladies and gentlemen, you would have heard it. But you didn't. So what did the state show you about Mr. Cowan instead? They wanted to talk about, they showed you pictures of a burning car, something for which charges were never brought against Mr. Cowan or Mr. Hill. I don't know how many times I heard Miss Norman talk about gang membership, being in a gang parties, drugs. How many times? Why did you hear about these insinuations? Was it simply because the state wants you to fear or be biased against these young men? I submit, ladies and gentlemen, these are relevant facts were introduced because they don't have any other evidence to implicate Mr. Cowan in this crime. Not a single witness, and I know you guys were paying attention, not a single witness who testified in this trial provided information implicating Mr. Cowan in this shooting. Not a single one, ladies and gentlemen. I know you were listening. The court will soon instruct you as to the definition of proof beyond a reasonable doubt. But here, the analysis is simple. Simple. No proof is not proof beyond a reasonable doubt. Speculation is not proof beyond a reasonable doubt. Maybe or possibly is not proof beyond a reasonable doubt. The proof that you need to hear to convict someone must come from the evidence the state presents. And in this case, you are no such proof as to Mr. Cowan. The court is also going to give you instructions as to first-degree murder. And I submit, ladies and gentlemen, after hearing all this, there is more than enough reasonable doubt as to this offense. But even if you get to that point, having heard no proof that Mr. Cowan killed anyone, you must then consider, how is Mr. Cowan criminally responsible for Mr. Hill's actions? How? Listen carefully to the court's instruction as to criminal responsibility. There has been no proof at this trial that Mr. Cowan solicited, ordered, directed, commanded, or helped Mr. Hill do anything. Mr. Cowan did not kill anyone, and he is not criminally responsible for anyone's death. Thank you.
Okay, Ms. Caitlyn, you presenting the closing. Do you need the podium?
I do. I'd like to take it place. I'm going to put my face on it. This way. Just push it over. Just still grab it. 6:08, 41 seconds, December 3rd, 2020. Devontae Hill's actions took the life of Caitlyn Kaufman. As they were both exiting at West End Avenue here in Nashville. Ms. Kaufman's on her way to work at St. Thomas West. Mr. Hill and Mr. Cowan are going to 115 Woodmont Boulevard to pick up his girlfriend. They're about 7/10 of a mile away in the same direction. It's a family's worst nightmare. It's impossible to comprehend the emotions they've endured and still endure. Devontae Hill committed a crime, but he didn't intend to kill Ms. Kaufman. His actions were unjustifiable, thoughtless, but he didn't intend to kill her. Devontae Hill should be held responsible, and he expects to be held responsible for the crime that he committed, but he's not guilty of first-degree and premeditated murder. There's been zero evidence to support that. In fact, the evidence presented all week is lack of premeditation, lack of intention. We talked about, I don't know, Monday or Tuesday now, how none of you are going to be asked to do something that you're uncomfortable doing. You're going to resolve a conflict, solve a problem, answer a question. Everybody does that every day. Stakes can't be higher than today. The difference is you just do it with a very narrow set of facts, with a very narrow set of rules that Judge Dalton will give you. You don't set aside your common sense, and I'd ask you not to. But what you do set aside is any preconceived opinion you might have about a gang member, or any bias, or any opinion you might have had coming into it, or any prejudice that we all have about a lot of things. You've heard a lot of stuff that makes you feel uncomfortable, and it may hurt. This case has been difficult for me. So set aside that stuff and be rational and impartial. Let's talk about the legal concepts and then the facts that you have to apply. Did I get the overhead? This is the jury instruction for first-degree murder. You don't even have to consider number one. We concede that. It's definitely an unlawful killing, and nobody's questioned that since opening statement. That's, yes, he unlawfully killed Caitlyn Kaufman. And he acted intentionally. Intentionally, the critical part of that is it's the person's conscious objective and desire to cause the death of the victim. Of course he intentionally picked up a firearm. Of course he intentionally fired it. But that's not what the intentionality applies to. The intentionality applies to, I want to kill that person. That's why there's degrees of murder. Because your intention has to be to cause the death of the person, not to pick up a firearm or fire it. It's the mindset of what you intend to do while you're doing those acts. That's where the intention. That's the intention. Premeditation. So you have to have the intention and the premeditation, both. In this case, we have neither. After the exercise of reflection and judgment. So first you have to have a conscious objective to kill, but then you also have to have premeditation, reflection, judgment, free from excitement and passion. The evidence in the case that you've heard is lack of any reflection or judgment, filled with passion. That's the nature of being cut off. That's the nature of road rage. It's not Miss Kaufman's fault. No one deserves that. But anyone who's been on the road and has been in an incident, whether it's your fault or someone else's fault, if you're in a crash or near crash-like situation, you can feel it in your body. You can feel the adrenaline. Of course it's an irrational and unjustifiable action. We're not disputing that. The state doesn't have evidence of intention, premeditation. It's a jury instruction for second-degree murder. Knowing killing of another, you concede the unlawful part. What's knowing? You can see that this definition doesn't have intentionality and premeditation. You're aware that your conduct is reasonably certain to cause the death of an alleged victim. This is critical because you don't have premeditation and intentionality here. There's a very significant difference. I'm not going to show you the voluntary manslaughter definition because we're conceding that there's an unlawful killing, and the definitions in there are what I've already given you. What's the law say passion is? Any human emotion, anger, rage. I mean, passion can be a positive, extreme happiness, joy, elation, sadness, anger, rage. Everybody knows what passion is. Everybody knows it when they see it. Doesn't mean passion is rational or reasonable or that it makes sense. Does it exist? reckless homicide. Unlawful killing, that's easy. You don't have to consider that. The defendant acted recklessly. What does the law tell us that reckless is? It's kind of a long definition. You're going to get this, so you're going to have a copy of all of these definitions with you. Recklessly. I'm not going to read all that. But everybody knows what that means. Everybody knows what that looks like. Everybody knows what that is when they see it. Now let's talk about the facts of this case. A lot of cases, there's a dispute in the facts. And Ms. Norman's initial closing argument, a lot of that would be extremely relevant if we were arguing that these are the wrong people. It would be extremely relevant to establish the identity of these people, certainly. But we would be foolish if we came in here and tried to mislead you and somehow say that it wasn't those two people. It was. So most of her closing focused on the stuff that we don't dispute. We don't dispute those facts. They were traveling at the same time, at the same place, down the interstate. Mr. Hill and Mr. Cowan were in Hermitage to visit his brother. They did get on the interstate. They did travel to the same place. We know Ms. Kaufman got on the interstate in Lebanon. They're traveling the same stretch of highway that many people do every day, and that many other cars were probably traveling through that day. Mr. Hill testified, we were at my brother's. We went to go get her. Ms. Norman mischaracterizes his testimony, and don't take my word for it. Don't take her word for it, because we're just talking to you. You guys have the evidence. I urge you to go back and listen to it for yourself. I don't want to tell you what the evidence says. I know what it says. I know what his testimony is. I want you all to review it. His testimony was very clear. I was really high on drugs. I really wasn't paying attention. But this is the critical part. I asked him, because he gave a bad answer. I will admit that. His answer was not clear. But when I asked him very specifically, how much time passed from when you hit the brakes and swerve before you started shooting, and he said immediately. There was no following. He didn't say that we waited. How much time passed between when this incident happened and you started shooting? I just started shooting. There's no one has disputed that. And frankly, that evidence is corroborated by Detective Dickerson, who's an extremely honorable officer. He told you the truth. This is what happened. It was a road rage incident. Mr. Odom, who wasn't there, and the only issue I take with Mr. Odom is that I don't think he's the good Samaritan that he purports himself to be. And that's not a character assassination, but he had that gun for, by his account, 4 or 5 days. Mr. Hill told you he'd had it since the day after. But in any event, he's had this firearm for almost a week. If he was such a good Samaritan that he just wanted to do the right thing, he would have probably delivered that firearm immediately or shortly thereafter, or maybe the next day after you talked to your mom. I have no doubt that his mom urged him to do the right thing, and it was ultimately the right thing to do. But he was coming for the money. You know, probably intended to ditch that gun for his friend, but $66,000, you know, can make you look different at your friends. Just simply no evidence to dispute what Mr. Hill says. The state wants you to believe this most outlandish scenario. Let me go back to Mr. Odom. He says that Mr. Hill told him that she was getting on the interstate. That's what he very clearly said, in court. He never said it at the preliminary hearing. He said it here because that's the best version to convict Mr. Cowan of something he didn't do. That somehow that there was this following. Great, yeah, that would be really bad evidence for us had they followed her 5-6 miles down the road and then shot her. That would be a really bad fact for the defense, and it would be difficult for us to overcome that. But that's not what the evidence is. They suggest that that may be what it looks like, but what is this cell phone tower data? Is it evidence of premeditation, or is it just evidence of coincidental traffic going east on 40, west on 40 at the same time at the same place? It's just a tragic coincidence. If she cut them off, so don't take my word for it again. Use the evidence, use the data. The data came from them. She maintains a constant speed the entire time. There's no fluctuation of her speed. We know that. She's driving normally down the road. They somehow want you to believe that she cut them off, didn't wreck, but then they were so far behind her that they had to catch up to her. Well, use your common sense. Somebody cuts you off on the road, you might be a few hundred yards, 1,000 yards behind them. It's going to take you, 15, 20 seconds to catch up to them at that point, at most? You could stop on the side of the highway, switch drivers, and easily catch someone who's driving 70 in far less than 4 minutes. Let's be honest. Mr. Hill made a series of terrible decisions after this incident. He's no criminal mastermind. It's somebody who made an irrational and thoughtless decision to kill someone else on the interstate because they cut them off. Why wait? If you're going to shoot somebody just because they cut you off on the highway, why wait? Why not get them? Why get them at the worst possible time when you're heavily in an urban area? We're talking about Hermitage, which is suburbs. There's less traffic and less stuff to see and less people to see you. The closer you get to the city, it's more traffic and more people to see you and more opportunities to be caught. So why wait? These guys that just doesn't make sense. That doesn't comport with our common sense. If you're going to shoot someone because they cut you off on the highway, you're simply not going to wait. So the data, I agree with the data, but I think what the cell phone tower data shows is that it's just two people traveling the same direction, literally going almost to the same place. And what makes the most sense is that when you're exiting at West End and 440, there's 4 lanes there. 2 of those inside lanes are exit lanes. One of those lanes you can go straight, one of those lanes is a dedicated turn lane, and the other 2 lanes are straight. Continue, go west. What makes more sense is that something happened right there where you've seen in the crime scene, whether they were driving fast and reckless, whether she didn't see them and accidentally merged over. Whatever happened right there, and he reacted to it. That's what the data shows. That's what the evidence supports. Not some grand plan to follow her, which just doesn't make common sense, and it's also not supported by the evidence. Frankly, the evidence of the ballistics and crime scene data and all that you saw was a grossly misleading characterization of that by Ms. Norman. Officer Belcher, Officer Whitaker, Dr. Warren, they all agreed with each other essentially and told you the same things, which is definitely not what Ms. Norman told you. You all were taking notes. I watched every one of you as much as I could all week, paying attention, taking notes, listening. All 3 of them said that it supported. I'm sorry, I'll take that back. Officer Belcher told you some information. Ms. Sims asked him very specifically, and he said yes, that it did suggest a passing. Dr. Warren one of the smartest people I've ever seen, an unimpeachable expert. He's not a hired gun for the defense. This man's got 20 years with the TBI. He still works for the government. He's just a scientist who gets hired to do a task and come in here and explain it to people like us in a way that makes sense, because it's some really complicated stuff. But at the end of the day, he said, yes, there's the relative motion. It all would have happened quickly. He told you, a firearm, this is what, at most, a few seconds. If you're not even a particularly, I think he said an expert marksman can shoot 8 or 9 shots in 1 or 2 seconds, which was unbelievable to me. But let's just say it's 3 or 4. That's what makes sense. Take the data that you have and apply your common sense to it. He committed a crime on the side of the highway for no good reason, but there was no premeditation or intentionality to it whatsoever. Ms. Norman went through a series of factors that you could consider for premeditation. Procuring a weapon. Well, there's no evidence that there was a procurement of a weapon. A procurement means you didn't have one and then you got one. I don't think anybody believes that Mr. Hill didn't already have a gun, and I think frankly he told you he had had it a while. So that does not apply because there was no procurement. That means you didn't have it and then you got it. She talked to you about calmness after the shooting. And it's not an unfair way to characterize what the cell phone data shows. It's not an unfair way to characterize what the pictures of the party show. I would submit that calmness is more applicable to immediately after, not days after. Is it insensitive? Is it unhealthy? Is it a maladaptive way to deal with something? To party and do all that? Of course it is. Of course it is. And it's kind of gross. But it's not evidence of premeditation. It's just evidence of really bad choices and coping with a messed up situation. But let's look into the data immediately after. If we were challenging this case as it wasn't him, we would look foolish to tell you that. Because clearly he knew about it at 7:37. He's searching it. But he was very clear, and I think common sense supports that. It could be calmness after the killing, but it could be what he told you, which is, once I kind of sobered up a little bit and was thinking a little more rationally, I realized I really messed up here. I wonder what happened. So if you don't know that you killed someone, maybe you're just hoping that you don't see what he saw and find what you found, and that you are kind of trying to carry on with your life and pretend that this horrible thing that you did maybe didn't kill someone. I think that's the more common sense explanation for that. Unarmed victim, of course, that is a factor that you can consider, but it's also irrelevant here. There's many unarmed victims who get killed. Yes, it could be a factor. We're not suggesting that there was any provocation or that Ms. Kaufman deserved this. Destroying evidence. Yes, it can be a factor. And certainly it's a factor of guilty of something, and we're not suggesting he's not guilty of something. Definitely is guilty of something, just not first degree murder. What you won't see in the jury instructions that the judge is going to read to you, you won't see any comments on procuring a weapon. That's not what she's going to tell you the law is. You're not going to read anything about calmness as something you can consider. You're not going to read anything about any of those factors except for destruction of evidence. And I think it's on page 17 of the instructions, the last sentence of a really long paragraph. And it very clearly says, destruction or concealment of evidence is not a factor that you consider for premeditation. So the only one that you're going to be read to that a law applies to, and that the judge is going to give you, says very clearly, destruction of evidence or concealment of evidence is not evidence of premeditation. there was some discussion about the number of shots. Well, we know that there were at least 6, of course. But again, this is where your common sense come in. They found 3 shell casings. We know there were 6 strike marks on the car. Did the police, are we suggesting that they fired 17 rounds or something thereabouts and that the police recovered no other shell casings? So they got 50% if there's 6 shots. They got 50% of the shell casings. There's 17 shots. I think that's unlikely. I think it's a distraction. It's an attempt to get you distracted on something else. And frankly, like, that would be their job, not our job. Like, lack of evidence is attributable to the state, not to us. Statement about the window down, I think Mr. Hill was clear, and I think it's, again, supported by what he said and supported what Dr. Warren said, is that if we have an incident where somebody breaks and swerves, there's not going to be time to roll the window down. If you're smoking weed on the interstate and you're trying to air out the car before you pick up the girl, you would expect the windows to be down, and I expect that they were. This whole, what he said in a jail call and what he said to Detective Dickerson, well, he's lying. He's lying because he doesn't want to get caught for a crime that he committed, and he's just making things up and talking about things. And again, go back and listen to the context of it. And it doesn't come out as clear as Ms. Norman would like you to believe. Don't take my word for it. Don't take her word for it. Listen to it for yourself. Re-listen to Mr. Hill's testimony if you need to. Please look at all the evidence. Don't listen to me. I want to address one more thing about the jury instructions. Is you're going to see a facilitation charge in there somewhere. Facilitation for the conduct of another. That does not apply to Mr. Hill. Mr. Hill, the state is not alleging he was facilitating anything. They have been very clear and very consistent, and frankly, we agree he did do the shooting. So you have to, if you don't do the act yourself, you can be a facilitator. If you did the act yourself, then you're not facilitating anything. Someone else would have to do it. So disregard that section when you come to it as it applies to Mr. Hill, because it clearly does not. I want to remind you of the burden of proof, and again, I'm not going to read those to you, but the burden of proof is on the state of Tennessee. The burden of proof is not on Mr. Hill. And we've somewhat made this a little bit easier because we're not telling you that you didn't commit a crime or that there's the wrong person who's sitting here being accused. He did commit a crime, he just didn't commit premeditated first-degree murder. So the state has to convince you, all of you, beyond all reasonable doubt, that they met every element of that offense. It's clear that they did not. And frankly, I think we have proven that those elements do not exist, and I think that's what the proof shows. If you take the state at their own word, through their own evidence, there's no premeditation. There's no reflection. The state has to go again because they have the burden of proof. So you don't get to hear from me after this. I have to be quiet and sit down, and I'm not sure what Ms. Norman or Mr. Moore or Ms. Taylor is going to say, but I feel confident that it will not focus on the relevant facts as much as it will focus on the things that he did after, the bad choices that he made, who he is as a person, concealing the evidence, trying not to take accountability. Those are all terrible bad choices. In hindsight, he probably should have owned up to this sooner. But people make bad choices in bad situations, and I'm not excusing it, but I think that's the explanation. Why didn't he stop? Why didn't they call 911? I think the evidence is supported that they just didn't know. Should you? of course, but you also shouldn't fire a gun out a window of a car going 70 miles an hour. So someone who may fire a gun out a car at 70 might not be too concerned about stopping and checking on the person or calling 911, regardless of their intentions. So yes, it's a terrible thing to do, and you should have done none of this to lead here. But that doesn't mean that you committed a premeditated, intentional killing of someone. I suspect that they will appeal to your emotions, your fear, your prejudice, your desire for vengeance, because it's strong in this case. It's strong. Just resist those emotional appeals. Resist the desire for vengeance. You're not here for vengeance. Vengeance is understandable. Vengeance is natural. And sometimes vengeance feels good. But you're here for justice. The first duty of society is justice. Justice for Ms. Kaufman, and a just accountability for Mr. Hill to convict him of the crime that he's guilty of. Justice requires impartiality and reason and objectivity. Your primary duty here is justice. This case is emotional. It's heart-wrenching. An innocent woman lost her life as she was driving to work. It's unimaginable. So I understand the emotion. But I trust that you all will deliberate on the law with your reason, with your impartiality, and return a fair and just verdict. Thank you.
Is the state presenting a rebuttal?
Yes, Your Honor.
You need to call the Mr. Gentleman.
That's fine. It is.
Oh.
Please, court. Members of the jury, the state does get to have the concluding remarks because we have the burden of proof. And in what will be, I sincerely hope, a very short time, you will hear the instructions of law from Judge Dalton, for which you will apply the facts that you've heard over the course of the past several days to the law to do justice. And yes, Alexander Hamilton is the one who had the quote that the first duty of society is justice. Well, what does justice mean? Black's Law Dictionary that we go by says it is the fair and proper administration of laws. The fair and proper administration of laws. We live in a society governed by laws. We live in a society where we strive to do what is fair and what is proper. If that is done, that is justice. Not partial justice, not lesser nor greater than what the fair and proper thing to do is. And members of the jury, in this case, perhaps a Freudian slip, but I wrote it down because I know you heard it. Mr. Chaffin said, he was talking about whatever gross mischaracterization, I guess it was, about saying that they could have fired 17 shots. He said, they fired 17 shots. That is the exact point of what we are here for. They did it. They killed Caitlyn Kaufman. It could not have been done by either one individually. And I ask you to think about when they said, oh, this sudden veer, stomp on the brakes, and it was immediately that he shot. Well, if that's the case, use your common sense.
Wouldn't he have shot into the back if it was immediate? You know, Mr. Hill, I suspect he knows the definition of premeditation as well as anyone these days, and what it takes to get away from that. Having the window down, because that is one of those factors, and General Norman went through. There are factors that you can consider. We know that from law. A judge can't tell you those because that would be commenting on the evidence. She's not allowed to do that. But all of those things, yes. If he had to roll the window down, that's a conscious decision, deliberation of what he's going to do after he gets the window down. But no, so, well, it needs to be down already. So, well, yeah, full of marijuana smoke, so had to air it out. Window was down. All the way, of course. Well, can't shoot out if it's just like, I don't know how many of you, if any of you are smokers, but back to common sense. How far do you have to crack the window to get the smoke out? To keep it from blowing back in. But again, it's perhaps one of those things that, yeah, it's better for the window to be down already. Does that make common sense? I submit no. But it helps. Oh, I just fired instinctively in an instant. Well, that's all the time it takes to premeditate. Repeated shots, yes. Unarmed victim who did absolutely nothing, even if she did accidentally, which that would have had to have been what it is, because she didn't keep doing it, even according to his testimony. Didn't happen. And she never knew what she had done to cause herself to be murdered. She's sitting and agree, maybe not so lavishly praised with Dr. Warren, but he didn't say anything that we disagree with. That car had to be alongside, to stay alongside for these shots to go in the way they did. We agree. The driver could not have swerved or hit the brakes upon hearing shots. They had to keep going parallel for it to happen that way. Yes. Dr. Warren says, well, yes, the driver would have to have kept going and kept going. Trying to get this down, the defense has to submit to, oh, well, this is just what happened at 6:08:41. No. However far back, however far into the future, the actions before, during, and after are relevant and are matters that you can consider. Didn't intend to kill her. Didn't intend to kill her. But one of the things about natural and probable consequences of your actions, who in this courtroom did we hear knows about what happens when you take a gun and shoot it at people? Yes, that came in to show, because it's not like he didn't know what he was doing. It was just, never had a gun in his hand before. It's just in his lap. Just takes it with him apparently everywhere. No, he shot 3 people before and injured them. He's had a gun in his hand. He had the gun at the ready, whether it was in his lap. We know it was in his hand by his own testimony, firing pulling the trigger, the brain saying pull, 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 pull. That's premeditation. That's first-degree murder. They did it. Aiding, offering to aid, encouragement. Devontae Hill could not have killed Caitlyn Kaufman without James Cowan, and vice versa. Three elements. Unlawful, thank you, yes. Intentional, just talked about that, yes, the intent. You fire a weapon time and time again into an occupied vehicle, not just into an occupied vehicle, but to the driver compartment. Premeditated. Yes. All of those facts. I could go through, have Jerome put up all of the things that she had up here to rebut what the defense has said, but you heard it. You've heard the facts. Going to hear the law in a few minutes. Talk about, oh, this is such as a tragedy. It's, yes, but it almost to sound like, well, Caitlyn, died of a drowning, or it was all of those things, but it was murder, first-degree murder. What causes some people to be willing to take the lives of others is beyond me. But that's why we do have the laws to be fairly and properly administered. Why we do have consequences for behavior. People are responsible for their conduct. It's the premise, Smith, that criminal law is based upon. That's why we're here. There was conduct. There was premeditated murder committed by these two defendants. You can have no sympathy or prejudice. One last thing the judge will say is, look alone to the law and the evidence. Look at the facts. Look at what we have proven. Was Gucci motivated by reward? It's one of those things that whatever it takes to motivate people, I wish that we could have a reward of that amount or greater in every unsolved murder. If that's what it took, in this case, it was money well spent. Caitlyn Kaufman died alone on a highway in this community, on one of the interstates in this town, on her way to work, listening to Cabin in the Woods, and no doubt waiting for that time to get to work to be able to call her mother as she's walking in. This case is about law and facts. And I want to echo what General Norman said to start with, and if she'll put it up about what, and it may take a second, that's why I'm going to say another thing or two, that common sense that's definitely something that these two defendants care little or nothing about having. And yes, you heard about the gang membership in the family, because that's what, for Mr. Hill, a loyal soldier, yes. I want something lesser, but if I can help my cousin, associate, beat the rap too, I'm going to do what I can. That's loyalty. This case is about Caitlyn Kaufman. It is about murder. It is about taking something they had no right to take. They did it. They are guilty as charged of premeditated first-degree murder. The law says it. I ask you to find it. We talk about, I'll just leave this one thought. I don't know how many of you might have Cabin in the Woods on your playlist, but every time you pull up and the light changes from green to yellow, and you make that decision, think about Caitlyn Kaufman. Thank you.
Your Honor, may we approach?
Okay, looks like we've wrapped up closing arguments. You see the courtroom is full in the gallery there. On each side, family of the defendants, and there are Caitlyn Kaufman's parents. So what, right now, she's calling them up there. What would this be for right now? With the jury still there, I guess.
Yeah, I'm not quite sure maybe they're wanting some kind of an additional instructions based upon something someone had said, and maybe they didn't want to draw attention to that. I'm not quite sure. I believe the state is the one who has to approach. Okay. So I'm not quite sure. I mean, typically you wouldn't see a sidebar at the end of closing without an objection or something.
Sure.
You might if the judge called it, but nonetheless, not quite sure. So, clearly I think Roger Moore did a great job on that one. You can see why Roger's the deputy. Roger's been practicing law probably since before I was born. I hate to say that, but you can tell he's got a lot of experience. He did a great job. Yep. And I thought Ron Munkabo did what he needed to do, and nothing anymore.
Yep. Ron Munkabo spoke for 6 minutes. Yep. Roger Moore there, 15 minutes, 30 minutes for Jason Chapin for Hill, and Jan Norman spoke for a little over an hour, and she really went point by point by point by point through everything, kind of revisiting everything they touched on.
And talking about premeditation.
And
evidence,
premeditation.
What can you consider to be evidence premeditation?
Yeah, if there's a common theme that you heard from them throughout, both her and Roger, was they did it.
That's right.
They, saying both of them are equally culpable, not just Hill. And as far as Jason Chapin doing what he could for Hill, I sometimes just think, as I was watching him, it's, you have to make do with what you have as the attorney.
He's a good lawyer,
attorney.
but he's got a heck of a bad set of facts.
That's a tough one. If you would elaborate a bit, just 6 minutes with Ron Munkabo for, his client. because he just reemphasizes there's no evidence that he had the weapon. He didn't shoot anyone. He didn't blah,
he
blah,
didn't
blah.
aid.
Yeah.
There's no evidence that he aided, solicited, or did anything that would suggest that he could be quote unquote criminally responsible for the conduct of another. And I think that's all he had to do is to hammer that point home. And I think that he did a good job. I mean, sometimes less is more. Part of being a good lawyer is knowing when to shut up, not, what to say.
We will parse through this. Let's listen in.
About 30 minutes. Are you all good for me to read it, or does anybody need a break? Okay, we'll go ahead and go through the jury instruction. You will get this jury instruction to take back with you as you deliberate, but I am required to read that jury instruction to you, okay? So be attentive as I read it. Okay. Give me a sip of water. In the criminal court for Davidson County, Tennessee, Division 2, State of Tennessee versus James Edward Cowan, aka James Edward Lillard, Devontae Lewis Hill, case number 2021B 726, first degree murder, charge. Members of the jury, the indictment in this case charges the defendants, James Edward Cowan, aka James Edward Lillard, and Devontae Lewis Hill, with the offense of first degree murder. This offense embraces the lesser included offenses of second-degree murder, facilitation of first-degree murder, facilitation of second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, reckless homicide, and criminally negligent homicide. You are instructed that for the purpose of these instructions, the defendant, James Edward Cowan, aka James Edward Lillard, shall hereinafter be referred to as James Edward Cowan. The indictment in this case is the formal written accusation charging the defendants with these crimes. It is not evidence against the defendants and does not create any inference of guilt. To this indictment, the defendants have entered a plea of not guilty. The evidence in this case has been completed. It is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in light of your own observations and experience in life. The law presumes that these defendants are innocent of the charge against them. This presumption remains with the defendants throughout every stage of the trial and is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt that the defendants or either of them are guilty. A defendant is criminally responsible as a party to the offenses charged or any of the lesser included offenses if the offenses were committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. A defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, a defendant solicits, directs, aids, or attempts to aid another person to commit the offense. To find a defendant criminally responsible for the acts of another, it is not necessary that you find that a defendant was present or that a defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of a crime is insufficient to support a conviction. Before you find a defendant guilty of being criminally responsible for said offenses committed by the conduct of another, you must find that all the essential elements of said offenses have been proven by the state beyond a reasonable doubt.
Further, you are instructed that a defendant may be guilty of facilitation of a felony if, knowing that another intends to commit a specific offense, but without the intent required for criminal responsibility as set forth above, the person knowingly furnishes substantial assistance in the commission of the offense. I will now proceed to explain to you what in law it takes to constitute the charged offense in this case and the lesser included offenses. First-degree murder, premeditated killing. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that a defendant or one for whom the defendant is criminally responsible unlawfully killed the alleged victim, and 2, that a defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, and 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the decision to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Before a defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of a defendant, by the conduct of another for whom a defendant is criminally responsible, or both. The proximate cause of a death is that cause which, in natural and continuous sequence, unbroken by any independent intervening cause, produces the death, and without which the death would not have occurred. If you find from the proof beyond a reasonable doubt that the defendants or either of them are guilty of first-degree murder as charged in the indictment by the defendant's own conduct or by the theory of criminal responsibility as explained on page 3, you will so report by use of the verdict form that will be provided for you. The court will thereafter set the punishment after a separate sentencing hearing. If you find the defendants or either of them are not guilty of first-degree murder, or if you have a reasonable doubt as to the guilt of either of them as to this offense, then and in that event, you must acquit the defendant of this offense and next consider the defendant's guilt or innocence of second-degree murder, which is a lesser-included offense. Lesser-included offenses: second-degree murder, knowing killing of another. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that a defendant or one for whom the defendant is criminally responsible unlawfully killed the alleged victim, and 2, that a defendant acted knowingly. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that a defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Facilitation to commit a felony. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that a defendant knew that another person intended to commit the specific offense but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and 2, that a defendant furnished substantial assistance to that person in the commission of the offense, and 3, that a defendant furnished such assistance knowingly. Knowingly means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct and that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that a defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Voluntary manslaughter. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following elements. 1, that a defendant or one for whom a defendant is criminally responsible unlawfully killed the alleged victim, and 2, that a defendant acted intentionally and knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The definitions of knowingly and intentionally as applied to this instruction have been previously explained to you. Reckless homicide. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that a defendant killed the alleged victim, and 2, that a defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that a defendant acted intentionally or knowingly. The definitions of intentionally and knowingly as applied to this instruction have been previously explained to you. Criminally negligent homicide. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that a defendant's conduct resulted in the death of the alleged victim, and 2, that a defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that a defendant acted intentionally, knowingly, or recklessly. The definitions of intentionally, knowingly, and recklessly as applied to this instruction have been previously explained to you. Sometimes in the trial of a criminal case, when a defendant is charged with a crime, this crime includes lesser included offenses. The law permits the jury to find the accused guilty of a lesser included offense, which is included in the crime charged in the indictment, whenever such a course is consistent with the facts found by the jury from the evidence in the case, and when the law is given in the instructions of the court. If you find a defendant guilty of a lesser included offense, the court will thereafter set the punishment after a separate sentencing hearing. When you begin your deliberations, you must first deliberate on the indicted or charged offense. If you find a defendant guilty of the indicted offense, you may stop your deliberations as to that defendant. If you find a defendant not guilty of the indicted offense, or you have a reasonable doubt as to that defendant's guilt, then you must find the defendant not guilty of the indicted offense and next consider the lesser included offenses. You should give separate consideration to each defendant. Each is entitled to have his case decided on the evidence and the law which is applicable to that particular defendant. Any evidence which was limited to a particular defendant should not be considered by you as to any other defendant. You can acquit both or convict both, or you can acquit one and convict the other. If you cannot agree upon a verdict as to both the defendants, but do agree upon a verdict as to one of them, you must render a verdict as to the one upon which you agree. Should you convict a defendant of any of the offenses heretofore defined and explained to you, it would be your duty to state in your verdict of what offense you find the defendant guilty. The court will thereafter set the punishment after a separate sentencing hearing. Members of the jury, I notice that some of the jurors appear to be making notes during the trial of this case. Please bear in mind that these are your notes and for your use alone. The taking of notes is simply an aid to memory, and the jury must understand that they are to recall the testimony and to use the notes only as an aid to memory, and any juror who takes notes will use those notes only for that juror's assistance in that regard and not as an authoritative thing to show other jurors. You heard and saw video and audio recorded statements. These statements were edited by the parties to remove portions of the interview that were not relevant to this case. You are not to consider in any way the fact that this has occurred and give what weight, if any, you deem appropriate to the portions of the statement introduced into evidence. You are not to speculate as to as to what was edited or why it was edited. The recordings contain statements by police officers and other individuals. These statements are not admitted for the truth of the matter asserted by these people. These statements of these people are admissible only as they provide meaning to the statements made by the individual identified as the defendant. You must never speculate to be true any insinuation suggested by a question asked or comment made during the course of these recorded statements. Only the statements made by the person you identify as a defendant may be considered by you on the question of whether the defendant is guilty or not guilty of any offense. Recordings were allowed in evidence, and you were provided with a document purporting to be a transcript of the recording. This document was provided to you to assist in your listening to the audio. If you're listening to the recording, listening to the recording, you find discrepancies or inaccuracies between the transcript and the recording itself, you should rely upon your understanding of the recording and disregard those portions of the transcript you find to be inaccurate. The court has charged the jury concerning an inference that the jury may make in regard to certain evidence in this case. However, the jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence or both, whether it exists in the evidence or the evidence of the state or is offered by the defendant. Although the defendant is not required by law to do so, when the defendant offers an explanation to rebut the inference raised, you should consider such explanation along with all the evidence to determine not only the correctness of the inference, but also the reasonableness of the defendant's explanation. You are not bound to accept either the inference or the defendant's explanation. The state must prove beyond a reasonable doubt every element of the offense before the defendant can be found guilty. Evidence has been introduced in this trial of a statement or statements by a defendant made outside the trial to show an admission against interest. An admission against interest is a statement by a defendant which acknowledges the existence or truth of some fact necessary to be proven to establish the guilt of a defendant, or which tends to show guilt of a defendant or is evidence of some material fact but not amounting to a confession. While this evidence has been received, it remains your duty to decide if, in fact, such statement was ever made. If you believe a statement was not made by a defendant, you should not consider it. If you decide the statement was made by a defendant, you must judge the truth of the fact stated. In so determining, consider the circumstances under which the statement was made. Also consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given to such statement. If you decide a statement was made, you should consider it with all other evidence in this case in determining a defendant's guilt or innocence. Any attempt by a person to conceal or destroy evidence is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. While that inference is by no means strong enough of itself to warrant conviction, yet it may become one of a series of circumstances from which guilt may be logically inferred. Whether the evidence presented proves beyond a reasonable doubt that a defendant so acted is a question for your determination. If this fact is proven, this fact alone does not allow you to find that a defendant is guilty of the crime alleged. However, since an attempt by a defendant to destroy or conceal evidence may be caused by a consciousness of guilt, you may consider this fact, if it is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. On the other hand, a person entirely innocent of a particular crime may attempt to destroy or conceal evidence, and this may be explained by proof offered or by the facts and circumstances of the case. Concealment or destruction of evidence of a crime is not proof of premeditation. Whether there was any attempt to destroy or conceal evidence by a defendant, the reasons for it, and the weight to be given to it are questions for you to determine. During the trial, you heard the expert testimony of Lisa Whitaker, who was described to us as an expert in the field of firearm and tool mark identification, Dr. Aaron Carney, who was described to us as an expert in the field of forensic pathology, Detective Chad Gish, who was described to us as an expert in the field of digital forensics, Special Agent Andrew Valley, who was described to us as an expert in the field of cellular communication data and analysis of cellular communication data, and Dr. Eric Warren, who's described to us as an expert in the field of firearm and tool-mark identification and shooting incident reconstruction. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. The guilt of a defendant, as well as any fact required to be proved by, let me start that paragraph over. The guilt of a defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of the fact in issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact in issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one or say that one is any better evidence than the other. You should consider all evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can without hastily or rashly concluding that any witness has sworn falsely, for the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any are shown, and all the evidence in the case tending to corroborate or contradict him or her. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When the witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. If you find from the proof that a witness has been convicted of some prior crime or crimes, you may consider such for the purpose of its effect, if any, on the credibility of the witness. The defendant, James Edward Cowan, has not taken the stand to testify as a witness, but you should place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. The defendant, Devontae Lewis Hill, having testified in his own behalf, his credibility is determined by the same rules by which the credibility of other witnesses is determined, and you will give his testimony such weight as you think it is entitled. The state has the burden of proving the guilt of a defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of this case. A defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute an offense. The burden is upon the state to prove by preponderance of the evidence that this offense was committed in Davidson County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that this offense was commenced or consummated in Davidson County, Tennessee, then you must return a verdict of not guilty. The state must have proven beyond a reasonable doubt all the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. The court charges you that the identity of the defendants must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendants now on trial before you are the identical persons who committed the alleged crime with which they are charged. In considering the identity of a person, the jury may take into consideration all of the facts and circumstances in the case. The court further charges you that if you are satisfied from the whole proof in the case beyond a reasonable doubt that the defendant or either of them committed the crime charged against him, you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the crime charged, then it would be your duty to convict him. On the other hand, if you are not satisfied with the identity from the proof, or you have a reasonable doubt as to whether he has been identified from the whole body of the proof in the case, then you should return a verdict of not guilty. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary. Let me start that paragraph over. I'm sorry. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find that the state has proven the defendants or either of them guilty beyond a reasonable doubt, then you should find him guilty. In that event, your foreperson will report that you find the defendant guilty and will name the offense agreed upon. On the other hand, if you find that the state has not proven beyond a reasonable doubt a defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. In that event, your foreperson will report that you find the defendant not guilty. You will be provided with a form for all verdicts in this case. The jury will check the appropriate verdict on the form, and your foreperson will sign the verdict form. The verdict form which you will receive reads as follows. In the Criminal Court for Davidson County, Tennessee, Division 2, State of Tennessee versus James Edward Cowan, Devontae Lewis Hill, case number 2021B, 726, first-degree murder, verdict form. We, the jury, find the defendant, James Edward Cowan, check 1, guilty of first-degree murder, or guilty of second-degree murder, or guilty of facilitation of first-degree murder, or guilty of facilitation of second-degree murder, or guilty of voluntary manslaughter, or guilty of facilitation of voluntary manslaughter, or guilty of reckless homicide, or guilty of criminally negligent homicide, or not guilty. We, the jury, find the defendant Devontae Lewis Hill, check 1, guilty of first-degree murder, or guilty of second-degree murder, or guilty of facilitation of first-degree murder, or guilty of facilitation of second-degree murder, or guilty of voluntary manslaughter, or guilty of facilitation of voluntary manslaughter, or guilty of reckless homicide, or guilty of criminally negligent homicide, or not guilty. This is our verdict, and it'll be dated and signed by the foreperson. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media, such as a telephone, cell phone, or computer, the internet, any internet service, or communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict, you will return to this courtroom and your foreperson will announce it. You must not imagine that the court has any opinion in regard to the facts. It is your duty to find them, and I have attempted to read this charge so as to define to you the law without indicating any opinion as to the facts whatsoever. Members of the jury, the indictment in just a moment will be handed to you, together with the charge and the exhibits in this case and the verdict form. In just a moment, you will be able to retire. But I have to identify the alternates. I think Madam Clerk has Okay, the alternates are identified as Miss Andrea Armstrong and Miss Emma Cobb. Andrea Armstrong and Emma Cobb. You'll come back in so that we can swear in the court officers. Ladies and gentlemen, let me also give you this, explain what, as you go to the jury deliberation room, while you're in the room, the 12 of you must be together in the room as you deliberate. If you take a break for anything, if one person leaves the room, deliberations must cease. All 12 must be present inside the room when you're deliberating, okay? So if like if there's a restroom or something like that, cease deliberations until all 12 are back together, okay? All right, let me swear in the court officers.
Do you solemnly swear or affirm that you will take this jury committed to your charge, keep them separate and apart from all citizens, allow no one to communicate with them or communicate with them yourselves on the subject of the trial, except to ask them if they have agreed as to their verdict, so help you God?
Okay. Ladies and gentlemen, you may step down.
All right.
Okay, so they will go out to deliberate. They will send the exhibits back, just so that you all know, I do not send the firearms back. If they have for any reason to view the firearms, we'll figure out a way that to happen, but all the other exhibits will go back to the jury deliberation room. The way that I handle any questions is that I will alert the attorneys if there are questions, and then we can determine if it's something that we need to bring them in here to answer, or if we could just send a response back. So I need y'all handy if it arises. All right.
Your Honor, may I ask a quick question? Are they going to be able to deliberate while they eat lunch, or is that going to be a separate break?
I usually do a separate break just because I want them to focus on deliberating. And the good thing is that they're there. Eating lunch shouldn't take long, but I want them to focus on deliberating, and while eating, some people, it may not be a distraction. Some people, it could be a distraction. Sometimes when I'm eating, I'm distracted. So I'd rather they focus. Anything else? All right. So make sure, I think that we have everybody's numbers. So, all right. I'll see y'all.
All right.
Y'all take signature in the back while you're getting the charge.
All right, folks, deliberations are set to begin. The evidence phase, closing arguments, the jury instructions, all completed after 7 days, and multiple witnesses The fate of the two individuals in the Caitlyn Kaufman murder case are now in the hands of the jury. Nick Leonardo with me. We're going to stay with you here for at least an hour or so. We're going to open up the phone lines. We'll look at your comments, your thoughts, what you think on guilt or innocence. As far as I typically like to try to get a time for when the deliberations begin. It wasn't clear to me there, but it sounds to me like she doesn't like them deliberating while they're eating. And so I'm guessing at 11:30, I'm guessing they're going to eat now, and the actual deliberations may not begin until maybe a little afternoon, but that's a guess. What do you think?
Yeah, I would agree. I would think maybe the jury already has their lunches here. I mean, I would think they don't even have the exhibits back there yet. So, I mean, I think the judge, saw the pace of the trial, saw how the closing arguments were going to go, and she knew how long it would take her to read the charge. And so she probably went ahead and had the lunches delivered. So I'm sure they'll go ahead and eat. And as soon as they're finished eating, then they will shut that door and they will proceed with the instructions. And the first order of business is to select a foreperson. And again, that foreperson's job is not to be some authoritative force or for somebody to say it is or is not the evidence that you've heard. Their job is to make sure that deliberations continue and they facilitate those deliberations. They're not talking about who's in the Super Bowl,
right,
or that it's going to be an inclement weather evening. All right, it's to make sure deliberations continue. But one thing we did see that I used to be a court officer here about 25 years ago in criminal court, and at that time it was for Judge Steve Dozier. He would swear in one court officer, and most of the time it was myself or another individual. But I saw that Judge Dalton swore in all of her court officers, which I think is a great idea because sometimes people could get sick, they might need a bathroom break, or they may need to go somewhere. So I think it's very helpful that they could switch out like that.
Okay, can you explain what you're swearing them in now? I mean, I don't know. I guess I would have figured those court officers have been there for the duration of this trial, right? Maintaining order in the court. Aren't they sworn in at the beginning, or why are they being sworn in now? I guess because they have to commit to making sure they supervise and everything goes well with the jury.
Well, if you listen to that oath, it's not only that you're not going to let anyone else interfere with the jury, but you yourself, as the officer of the court officer, you're not going to interfere with that jury. So it's an oath, and they can be punished for violating that oath. And sometimes you may have one or two out of the merry band of court officers that maybe say something they shouldn't say. Of course, not any of these folks, but over the years, we've heard of those things happening.
Sure. No, I remember a couple occasions. All right, listen, Nick and I will share some of our thoughts on what we've heard in closing arguments. And then, as I said, the phone number's up, 737-7587. You can be watching us on Facebook. Mention there at newschannel5.com. You can send us messages and your thoughts there as well. We're viewing it right now on YouTube, the station's website, our YouTube channel. So, Nick, let's give our opinion, and then I want to hear what all of you think in terms of guilt or innocence, perhaps moving forward. From the closing arguments today, what stuck with you from whether the prosecution or the defense, or maybe each?
Well, I guess what stuck with me on the side of the prosecution was that I think Roger Moore, Jan Norman did a fine job. She always does. These are all great lawyers, but Roger Moore's closing argument kind of stuck out to me because he really did humanize, why we're here, and the Cabin in the Woods song that she was listening to. I think that was very effective on his behalf. And then I think that defense attorney Ron Munkabo, Mr. Cowan's attorney, he did a good job in the fact that he spoke for 6 minutes and he says, look, there is absolutely no proof in the record that he aided or that he assisted or that he solicited or that he promoted or any of those things. And so, I think he did a good job of pointing that out. I mean, the evidence comes from the witness stand and the exhibits that are introduced at trial, and the jury is solely supposed to make their decision based upon that. And so, if I were a jury, I probably would find Mr. Cowan guilty of facilitation of first-degree murder, and then I would find Mr. Hill guilty of first-degree murder.
Okay, and explain the facilitation. That's a lesser charge. It's not life in prison. What would that mean?
Well, so facilitation is that you knew the other person intended to commit the specific felony, but you did not have the intent to promote or assist in the commission of that felony. However, you did provide assistance. Okay, so there's a little bit of a difference there. The fact that he did provide some assistance. He was driving the vehicle, but there's no proof that he knew he was going to shoot and that he assisted him in shooting. Okay, those are inferences, and there's some circumstantial evidence that this jury gets. This is a completely circumstantial case, and under Tennessee law,
have the gun.
Well, they have the gun, but there's no prints on it. There's no DNA. I mean, the fact remains is that circumstantial evidence is of equal dignities in the state of Tennessee is direct evidence, and they could sustain a first-degree murder conviction based upon that. So facilitation means that you provided assistance, but you didn't really have sort of the same intent as the actual trigger person to commit the offense, which was what's committed.
Here's my issue with that, and I hear you, and you very well may be right, but there are probably other points some will think of, but here's my problem. She cuts him off, okay? He's in the car, remember, driving, and right next to him is his buddy Hill with a 9mm in his lap.
We don't know if it's next to him. We don't know where he's seated in the car.
What?
We do not know where Hill is seated in the car. He could have been in the back. We don't know that it's next to him. There's been no testimony as to where he was seated.
No, he was sitting next to him, I believe. The window was open on the side. There's been no testimony that Hill's been in the back seat.
But there's been no testimony where he's been either.
Really? Well, the car was parallel. And with the window down in the front,
Still
no testimony in the back. Well, okay, I'm telling you what I would have heard, and I've sat through here like the jury. He's sitting next to him. He's not sitting in the back seat with his buddy. Common sense. Let's put some common sense in here. Common sense. He's chauffeuring his buddy Hill around in the back seat.
Well, and clearly, common sense. They're not going to check that at the door. But again, that's the danger here in a criminal trial, is that juries will infer into evidence. How many phone calls have we had, and how many comments have been made about where's their moms and dads, where's their family, right? That's not in evidence, but those are the things that juries look at. And you're right, there are inferences to be drawn.
Well, even if he is in the backseat, it doesn't change my point here, but I'm guessing these guys claim that they were smoking, and they're passing the doobie back and forth here, and he's in the front seat with a 9mm on his lap, okay? She cuts him off, and he's clearly in front, and Roger Moore said this in his closing, okay? If it was just a spur-of-the-moment thing where Cowan had no role in this, the bullets would have come from behind. No, Cowan accelerated, got parallel with the vehicle next to him, and his buddy with the gun then is able to shoot right through the window, nailing her in the arm, and then it goes in and kills her. And that's the problem. It's like he accelerated to catch up to that vehicle, and that makes him every bit as guilty.
Okay, and what if, let me play devil's advocate with you. I mean, that's the inference that the state wants you to draw, but what if they got cut off and he got mad and he hit the accelerator to go around her, and he was just literally trying to get around her, but yet here you go, Hill's shooting out the window, okay? I mean, there's inferences that can be drawn both ways. That's the thing.
Yeah, they're both going 70 miles an hour at that point. And then what about, though, the other part of it in terms of criminal responsibility with covering it up later? I mean, truly, if he had, didn't stop to give aid, didn't call 911, after the fact, they're off partying 2 days later, and they all know exactly what happened. Does that not come into play at all with Cowan?
I think so. And remember, it's evidence of premeditation, and Jan Norman said it in her closing, and it's important to point out that premeditation can be formed in an instance, just like that, okay? It doesn't have to be something I thought about all night long or, considered for 20 minutes before I made the decision. Premeditation can be formed in an instance, and you can also consider these individuals' actions to secrete their activities or to cover up what they did also as evidence of premeditation. And of course, the state would have you believe, and I think we know it's the same vehicle that they were in was set on fire, like in an arson act, okay? So clearly they would have you believe that that was an effort to secrete their activities because they knew what they were doing was wrong. And actually the gun with Hill. I mean, Hill trying to get rid of the gun and telling Odom that this gun is essentially hot, okay, that he needs to get rid of it, clearly is evidence of trying to secrete the activities of which you were engaged. And so those can be considered as evidence of premeditation as well.
The mere fact that we brought up these different points of view when it came to Cowan is I am in agreement that if there's going to be some kind of stumbling block or some delay maybe with this jury coming back with a verdict, it's going to be that there's a possible debate going on about what
I think that's the only stumbling block.
Let's go to Hill. Is anyone out there, and I want to share it, we're going to take phone calls. Does anyone out there honestly think that Hill is not guilty of first-degree murder after what we've heard? Nick, you talk about maybe having different opinions or, not answering some on the evidence. Does anyone out there honestly think Hill is not guilty of first-degree murder?
I think that he is. I think that
No, he is.
Yeah, absolutely. I just don't see a lesser on Mr. Hill. And if you wanted to give him a lesser, he wasn't, I don't know that he was as honest as maybe people would have liked to believe, and I don't think he did as good of a job on his own testimony as he could. Again, there was no, I'm sorry, and looking at the Kaufman family and apologizing. And I just think that is a threshold issue once you admit you're the person that pulled the trigger.
Yeah, we never heard, and that could have helped him maybe to some degree with a juror or two, remorse.
And
we never saw
speaking
that.
of jurors now, the judges, she read the names, and I don't know if we were able to block that in the control room, but so clearly there were 2 females that were dismissed from the jury now. So our 12 are now comprised of 3 men and 9 women.
Yeah, still predominantly female.
Predominantly
jury.
female, that's right.
So, all right, let's take some phone calls and see. You can agree, disagree, whatever, and we'll also monitor some of your comments on Facebook as well. We'll go to Barbara. Good afternoon, Barbara. Go ahead. Hi.
Hello, Nick and Nick. You two have done an outstanding job. And I think that both attorneys, all of the attorneys have done a good job. Jan Norman is just incredible. But you have addressed the issue that I was going to bring up about the difference, the different types of convictions they could have, like the facilitation of first-degree murder. If I were on the jury, I would say 100% first-degree murder for Devontae Hill. And then I'm kind of vacillating back and forth between first-degree murder or facilitation of first-degree murder and leaning more toward facilitation of first-degree murder for James Cowan. One of the reasons being that it's just like Nick, you said, well...
Which Nick?
I'm sorry for your last name.
Nick Leonardo or Nick Barris?
Yes, Mr. Leonardo.
Yeah. We could do young Nick or old Nick.
There's still a little bit of question as to whether Cowan accelerated and went around and kept going, because I still, this term of relative motion keeps sticking in my mind, because I think one of the experts said something about for relative motion, if both cars were moving at the same rate of speed, then there would be no difference really in the angles of the gunshots or the entrance of the bullets, and so that keeps sticking in my mind. Anyway, long story short, what is the difference in the sentencing of facilitation of first-degree murder and first-degree murder? I guess I'm...
Okay. Yeah, you want to go ahead on that? And keep in mind the jury will not know this difference unless they just happen to know it before they came on the trial.
No, unless they Googled it. But the judge did say that, if there was a conviction, that she would sentence the defendants after the fact at a later date. So again, the jury's not involved in sentencing. But first-degree murder is, the penalty is life in prison. Okay, that's pretty much it. And then on facilitation of first-degree murder, I believe that would be an A felony, which would be punishable by 15 to 60 years. And then, of course, it's going to depend where you fall in that range. Depends on the prior convictions that you have.
Okay. Looking at some of the comments, Janice agrees common sense is not evidence, which is what you were kind of saying.
But they never check it at the door.
No, I was going to say, and I don't want a jury to check it at the door. Evidence and common sense may not be evidence, but you even talked on this. Aside from that evidence that we're talking about, you think that Cowan may have been damaged yesterday by Hills taking the stand simply because he's associated with this guy who's up there trying to defend him, probably not telling the whole truth. They're co-gang members, and just by the association, because I'm just telling you, this jury does not like these two. Okay, there's nothing to like about them. And probably not liking Hill any more than Cowan, maybe worse, but those emotions come into play. They're looking at the parents sitting there and they're hearing this. They're not hearing any remorse, and Cowan and these two are buddies. You were saying yesterday how some of Hill's problems can kind of blend off onto Cowan.
Well, and I think that's one of the reasons why you don't, as a criminal defense attorney, you really don't, it depends on who you have, but 9 times out of 10, you really don't like being tried together because you're afraid that this person's dirt is going to get onto you.
Guilt by association.
Now, if everybody sits there and they're quiet and no one testifies, maybe it's not so bad, but as soon as Mr. Hill took the stand, I guarantee you that Mr. Bunkabo had a lot of indigestion.
Yes. As far as whether anyone witnessed this shooting, as far as we know, there were no witnesses to the shooting. There are T-dot cameras on I-440, but they do not record. So there's no video of the shooting and there are no eyewitnesses. Let's go next to Taylor. Taylor. Good afternoon, Taylor.
Well, good afternoon to you.
Hello.
It's been a long time, Nick. As I told you some time ago, I was a court reporter in strictly criminal court for about 8 years, and so I have sat through an awful lot of trials and sat and waited on jurors for hours and days. But anyway, I've got a little different take on Cowan in this situation, and I'll just say out flatly, I think he's possibly the most dangerous of the two, that being his reputation in the community and the fact that nobody is afraid to say anything about the guy, and the gang members would sure hold it against the other fella if he were to say too much. Now, we don't know what was said in that car when it's cut off or whatever happened, but normally it's the driver that's the most offended in something like that. And I can imagine some very serious conversations about this case that took place right at that time up until it was over. So that's just my part on that. Secondly, though, I want to say a big thank you to several members of the police department. This has been an outstanding group that has testified. The Chief Detective Dotson, I think was his name, he and those two fellows concerning the phone calls, they testified as well as any FBI agent that I've ever seen take the stand, even better than a lot of TBI agents. But I just commend our police department for the value and honor in those guys, and I am convinced that both of them are guilty of first-degree murder all the way. And of course, we've got an open case right now from Christmas Day of the same thing over near the stadium, which is a sad thing too, because that fella had 3 or 4 kids. It's something that's got to be stopped.
Oh, listen, that's for sure. And he's right. Chad Gish, who's done this before.
He's a rock star. Chad Gish is great.
Well, he's terrific.
As far as a witness.
And Andy Valley with the TBI, who kind of complimented the two of them, were really key.
But, and Sergeant Dickerson, who has done a masterful job. I mean, both of those two, Detective Gish and Sergeant Dickerson, who was the lead investigator, they were great witnesses. And he made the statement they testify better than FBI agents. And quite truthfully, someone like Gish or Dickerson testify a heck of a lot more than most FBI agents ever see an opportunity to testify. A lot of those cases in the federal system don't go to trial.
Someone on Facebook was asking, they haven't heard the names of the jurors revealed before, and the reason you heard the names of those two is that they've been excused now. You're not going to hear, we don't show them. Afterward, you can get the jury list and the names of them. Sometimes they talk, sometimes they don't. But that's why that was made public in open court there, because they've been excused. They're done. They were alternates in case someone got sick. I wouldn't release the jurors until the verdict came back. What if a juror falls out now with some kind of medical emergency?
So there's some case law out there that says they could still continue potentially.
And come back with a verdict with 11?
I can't remember. We've had this come up before, but I want to say that I think that they could if there was one missing. But there's no real magic number. But clearly, at some point, that's even no matter what the judge decided, it's going to be a basis for an appeal.
So that's why I would try to keep the two. You say, I've chosen you two, but I'm going to have you guys just sit to the side, whatever.
But the judge also probably thinks deliberations aren't going to take so long.
You may be right, and I'm in agreement with her. When you picked up that little brown notebook there, I know that's your calendar, but it made me think about what we saw in Cowan's hand in the courtroom. And in fact, you caught that moment and showed it to me. I know that's your calendar, but you believe, is that Cowan with a small Bible that he was holding up to his face?
Yeah,
I believe
that was a Bible that he was holding up in front of the jury. It didn't, you couldn't see the words Holy Bible on it, but he was holding a Bible.
Holding it right there. And do you think that is orchestrated?
I think, I don't know that it's necessarily orchestrated. That'd be given a lot of credit. I just think that, they're hoping for a good outcome, honestly,
Okay.
And
well,
and
the jury's going to see that.
And he's over here, his position is, man, I didn't have anything to do with this,
Yeah. All right, let's go to Norma. Norma, good afternoon. Hi, Norma.
Hello there.
Hi there.
How are you guys doing?
All right.
Well, I think they're guilty, first degree. I think the state has done a tremendous job in creating a timeline, data forensics, yada, yada, all of that. Facilitators, that too, because facilitators are any person that make an act come together, whether they do it or not. They help put the deal together. And the driver certainly had the last clear chance to navigate that car, either by saying, oh, it's not worth it, it's not something. And I believe it's no way that he didn't know what his pal, if he had not even instructed him. He was the guy that had control of the brake, the acceleration pedal, everything. The intent of the driver had to be in line with the shooter. If not the offender, he might be the bigger offender, actually, because he had to say something, because he would have been the most enraged by the fact that somebody would have cut him off.
Possibly so. Possibly so. I mean, I think that's exactly what Jan Norman was saying. And as I said throughout this, the theme was they did it, and that one could not have committed this crime without the other. And again, it does go to 6 shots fired. I mean, if he, and you're right, he may have just been accelerating to get back around her and go, but he pulls up to a point and then 1, 2, 3, 4, 5, 6. It's just hard for me to get past that, thinking that he was just a almost innocent bystander behind the wheel, which is what, Munkabo wants you to believe.
Well, but, one thing, I guess, and we had the prior caller said this, and, clearly if that was us riding down the road and you shot, 6 times, I mean, I would say, what in the world are you doing? If I didn't have any idea you were doing that, right, I'd be like, what did you just do, Barris?
Sure.
This is crazy. The heck with you, we're all going to get in trouble, right?
But if you or I are co-members of the Crips gang, and if you are aware of my violent past history and you're aware of mine, and we're driving down the road, and as we're cruising, we're not only doing drugs, but I've got a 9mm in my lap, you know who you're with, okay? It's not like you and I all of a sudden, how shocked would I be if you and I were going to lunch and you pulled out the gun and shot? I'd be absolutely stunned.
That's right.
Well, you know what? I don't think Cowan was all that stunned that his friend did this, because he knows him. You know who you're in the car with.
Well, and he's got a gun sitting on his lap.
And a gun on his lap. That's the difference. If you just surprised me, of course, all of us watching would be stunned if someone we knew did that out of the blue. These two, consider their background. Consider who they are.
Well, and and that's where I think there was a lack of candor. And
right.
Truthfully, maybe Mr. Hill didn't understand any conversation that ensued between him and Cowan after he shot 6 shots. But this wasn't 1 shot. This was 6. So there was certainly a conversation in that car before they got off at Sharondale and threw the casings out the window, which they did, is what in the heck did you just do? And we are in trouble. There had to be a conversation.
Let's take another one from Harmon is up next. Harmon, good afternoon, Harmon.
Good afternoon, Nick.
Hey, what's on your mind?
Well, before I get into a diatribe, I'd like to ask a couple of questions, if I may. We talk about Cowan holding the Bible, which I think is hilarious.
We think it's a Bible. Yeah.
Well, exactly. But the other thing is, I noticed that Hill was wearing, I wouldn't call it a yarmulke, but was his headgear in the courtroom, is that a religious inference of some type? Because if it is, it failed miserably. I think that what we're going to be looking at is, personally, I'm of the belief that we're going to be looking at first-degree murder on Hill and probably facilitation of first degree on Cowan. And probably my take on things, the way that Hill's testimony was in regards to Cowan's non-involvement, I think that he is definitely afraid of what is going to happen to him for this whole situation. He knows that his days in prison will be numbered simply for the gang affiliation and whatnot. I guess the word I'm looking for is revenge. I think that he's in fear of his own life, and I also feel that he was probably trying to impress Cowan by shooting at Miss Kaufman.
Okay. hard to know for sure one way or the other. It is a given that coming into this trial, based on the opening statement from his attorney, he'll acknowledge he's going to go to prison for a period of time. The question is if it'll be for the rest of his life.
Right.
He just says it's not first-degree murder.
And the hat is, indicative of the Muslim religion. Maybe it's called a kofi or something like that.
Yeah, that's the type of headgear. At least we've kind of searched out that type of headgear. And I don't know what he would tell you about, but yeah, it is indicative, that kind of headgear with the Muslim religion, if perhaps that's him. But we don't know. No one's been able to ask him that.
Proof that came in about that.
No, but it's his choice. He didn't wear it every single day. Remember, he wore it during jury selection. Then it wasn't there for the first day, and it's been back the last 2 days he's chosen to wear it.
I mean, we're in Tennessee, and you're charged with murder. And my advice to my client would be, don't wear it.
Okay, and they've been wearing suit and tie or jacket and tie most of the time as well. So, yeah, juries notice things like this, and they make assumptions perhaps. Let's go to Joe. Joe, good afternoon. Hi, Joe.
Hello.
Hey,
how are you?
Good. What's on your mind?
Miss Kaufman was going to work at St. Thomas West at 6-something in the morning. Is that right?
In the evening.
In the evening?
Yeah.
That leaves a little, because they keep on saying evening, which is PM. And I thought that she'd be going to work at 7 o'clock, which is start of a day shift.
I forget what they said. They addressed this. It had something to do with, she worked different shifts, but she was going in that evening, and I forget exactly why in that circumstance. Again, she worked in a COVID ward, was there during the pandemic, but she was going in that evening, and I forget what it was, but it was some shift that she was scheduled for. Do you remember what it was?
I'm not sure. I don't remember what it was, but I do know that I had received a Facebook message from an individual who was actually, it was a really sweet message that was actually in the hospital, and Caitlyn was the nurse, and she would talk about how Caitlyn would still come by and visit her on days she wasn't working.
Even when she was off. She was a committed person to her patients beyond just being a nurse. By all accounts, she was terrific at what she did and had a very bright future. Let's go next to Mike. Mike, good afternoon, Mike.
Hey, Nick and Nick, thanks for taking my call.
Sure.
Hey, just a couple of things I thought maybe the prosecutor could have handled a little bit harder. It was 6:08 at night, and in December, we're also talking about a couple of things. The weather, number one, it was raining. I know that the defense attorney said he thought they were airing the car out, riding around with their windows down, but I know for a fact that it was raining quite well that night and kind of cool, so most people don't ride around with their windows down when it's raining and it's cool. And the second thing was, it's also going to be dark at that time. And I know there is lighting on 440 coming down from the 65 down to the Hillsboro area, but, he stopped, or he hit his brakes, and then he had to catch up. And, someone might say, well, he was mad, he was just going to get around her. Well, if he was going to get around her, he wouldn't have pulled up beside her and marked speed with both cars while this guy was shooting. And I don't know about you, but if I'm driving on the road and something pops in my car, I'm going to react to it pretty quick, brake, swerve, or something. So that's just my point. I think they're both guilty of first degree, and I think Cowan may get a little break, like you said. But the other thing was, he's also a convicted felon. He had aggravated robbery charges, and I think served a little time. He was riding with a handgun.
Well, that's right. And Nick, you said the jury doesn't know his priors in Cowan's case, but that would come up at sentencing.
Oh, absolutely. That's what the judge has got to look at. Unless he is found guilty of the indicted offense, which is just going to be a sentence of life on first-degree premeditated murder. But there would still be a sentencing hearing, but it couldn't add any more time to it, right? But clearly, if there is a lesser charge of which either one of these individuals are convicted, then your prior convictions, prior felony convictions, certainly prior felony convictions, make a big difference in the amount of time that you're going to get. So if you have, as it stands to reason, if you have prior felonies, then the punishment in this case needs to be greater as a result of the prior felonies.
And I know you said this earlier, but could you repeat it for our viewers? Just what, if it's facilitation he's convicted of, I know it may vary depending on the range, but what type of time could that bring?
So, if it's facilitation of first-degree murder, that could still bring 15 to 60.
Okay.
And then if it was facilitation of second-degree murder, then they could potentially be looking at somewhere between 8 to 30, if that's the case. But I think if there's a facilitation, think it's going to come on the first-degree murder charge. I don't know that there's enough proof that there was facilitation of second.
But that's quite a range of what the sentence could be, and it would be based on a number of factors, including his priors.
That's right.
Prior convictions. Okay. Got something here from Mary saying that she thinks the defense did a good job providing information for how long the event could have taken. Their experts saying that 6 shots could have taken 3 seconds, and his hand would have been stationary. Provides the option that maybe he actually did this without thinking. She thinks that the defense may have done a good enough job, perhaps with regard to both of these defendants, to raise a level of doubt.
You know, but one thing that I'm sitting here thinking that we never really got to the bottom of, and that was the shell casings that were found at Sharondale that were part of this firearm. So if they're shooting, you know, some of the shell casings must have come back into the vehicle, okay, because it ejects out the side, the empty or spent cartridges do. And so the fact that they may have been cleaning out the car after this happened is even more evidence of premeditation.
All right, let's go next to Bob. Bob, go ahead, Bob.
Yes, thank you, Nick.
Sure.
Nick, for taking my call.
Yes.
And you just covered what I was talking on call about.
Sorry.
Is the three shells that they didn't find. Well, when they was passing the car and shooting, it would inject the shells into the Cadillac.
That's right.
Which would show more of a trajectory. You know, because if the gun was pointed this way, the shells eject out the right side.
Right.
Okay, and so that would show really how far out the gun would have been. You know, and if they, and of course, I believe the shells that were found at the corner of Sharondale and Hillsborough Road were actually consistent with the Springfield Arms 40 caliber.
Right.
And of course, again, there was not much hay, you know, made about that. But again, when this started off in opening argument, Hill's lawyer said he shot her. So I guess maybe the state just, you know, worked with that statement instead of all of the other circumstantial evidence.
Thank you for your call. Donna's asking what a lot of people are wondering, how can we tell when the jury will come back? Meaning, will we let you know? And it's just a matter of when a decision is reached. As you know, they've probably been back there now for the past half hour. We think they went back to initially eat lunch while they're getting all the evidence back for them. So I don't think they've actually started probably getting into the deliberations, or if they're going to, it's going to be right about now to 12:30 would be my guess, because the judge said she doesn't want them deliberating while they're eating. And then they'll jump into it. And on occasion, we've seen in the past where a jury will have a question and they call the judge back in and they may ask a question about some evidence. That could happen, but short of that, tell folks how we'll know when they have a verdict.
Well, you'll know when you have a verdict because the court officer will report to the judge, okay, and that we got a verdict. And then Ms. Franklin will call the attorneys and tell everybody come on, and then it'll get back to Bud, the photographer, and some of the Channel 5 reporters, and then we'll bring that to you, and then they will have to get the lawyers back there. I mean, a lot of these lawyers, I mean, probably the DA's office is across the street. You know, Jan Norman and Roger, you know, may have gone over there, or they have an office on the 4th floor of the Birch building. Maybe they're down there eating lunch, but they're not going to get far. And Mr. Munkabo is not going to get far as well, because if they do have a question, everybody will be brought back into the courtroom.
Yep, exactly. They stay nearby. So I just want you to know, you won't miss a thing. We will know when that happens, and we will break to it if anything happens in the courtroom. But it is interesting. I've been over there before, and it can be a nerve-wracking time for both sides as they wait. And you're right. Sometimes they go back to the office. Sometimes they sit in some of those side offices there, but they don't go far at all. And so when the judge calls, everyone's back in that courtroom sometime within 10 to 15 minutes tops, and they're ready to go.
Yeah, you know, and there's a sense of relief by all these lawyers, okay? I mean, these lawyers have, you know, there's nothing like getting ready to go to a trial, and then there's nothing like doing it. And once it's over, it's such a feeling of relief. I mean, it's now over but the verdict, but as far as these lawyers having to, you know, wonder about what they're going to say next, you know, that part's over with. And so I would think that, you know, if you're Mr. Munkabo or you're the public defender, you may be returning some other client phone calls. You may be working on something else that you have as a deadline. But now you can, for once, finally think sort of freely and not have to worry about, well, what am I going to say today, tonight, tomorrow? You know?
Yeah. Now, you have the belief, one way or the other, when they start deliberating, the longer it takes to come back. Is that in any one side's favor to your experience?
I think it's in everyone's favor with this set of facts. I mean, you know, we have covered maybe 15
No, I
of
mean,
these.
is it more good news for the prosecution or for the defense if
the defense
if they
with
don't,
this set of facts? The defense with this set of facts.
With this set of facts, I agree.
Yes.
The longer this takes, the better it is for the defense. In my opinion, if they start deliberating at 12:30 for real after they finish eating lunch, we may never know exactly the time they start. I would think they should be back with a verdict by 3:30.
Well,
and if they're not back by 3:30, then it's going to take a while because somewhere something's going on.
Well, and I would think too, normally you get an hour for lunch because Judge Dalton has given you an hour for lunch, and there's really nothing else you can do. You're sitting here with these 14 strangers, and y'all can't talk about why you're here.
Yeah.
So it's a very odd sort of thing, and you do make relationships because you got to shoot the breeze. You're in there, and so you use your hour for lunch. But when you know that as soon as you finish, you can begin, I think people eat a little quicker, get done a whole lot faster, so they can get the process moving.
I agree. Yeah. So they may be underway right now. Let's go to, I think, line 8, and that's Tony. Good afternoon, Tony. Hi, Tony.
Hey, you guys are doing a great job.
Thanks, Tony.
I don't think that I might have missed this because I ain't been able to watch everything for my working and everything. But now, facilitation. When we're talking about facilitation, with a driver of the vehicle that they were in. If there's electric windows, the driver can also push the button and roll down the window for the shooter, or roll it up in any case. So yeah, okay, it was raining, so maybe the driver rolled the window down. The passenger don't have to. The driver has the option. If it's electric windows, he can roll the window down halfway up.
Well, you're not wrong. We don't know who rolled it down.
That is what the jury's not supposed to do. Okay,
Yeah.
but I don't blame Tony at all. I mean, that's definitely something
you're gonna
people
go
think
there.
about. But again, the evidence that they have to consider is the testimony that was given from the witness stand and the exhibits. They're not to consider anything that the lawyer said or any of the rulings that the judge made as to evidence. And so, but you can't help the fact to think that the jury looks at inferences, and that's what jurors are talking about, things that aren't into evidence. Well, maybe the driver window, maybe he could have controlled them if they were, and nothing has Armstrong windows anymore, right?
Right.
So, but again,
Power
see
windows.
how easy it is to get down this rabbit hole of
No,
what
you're
if,
right.
and you have to stick with what the state's got the burden of proof. Okay, I mean, clearly the state functions at a high level. They have a hard job. Okay, they have a very hard job, and what they do is important. And if someone killed one of our loved ones, those same lawyers are going to be there getting justice for us. But I don't think anybody would disagree that the defense certainly has a more difficult job because they've got to pull rabbits out of hats or hats out of rabbits. I don't care what you say. The job is much more difficult with that set of facts.
All right, but now as a juror, you want to try to deem credibility. I want to ask you this along the lines of the window coming down. All right, you have Hill talking about how they were smoking and they rolled the window down. This is December 3rd. It's wet, it's rainy, and it's cold out. Now, my image on this is that window, and again, we don't know for sure, but he says the window was down to let the smoke out. I'm telling you, it was not all the way down. In fact, I'm guessing the window was down like this because it's cold and wet. You got it all the way down here, you're getting wet, it's cold. That just does not make sense to me. Now, I do think, though, when they pulled up and decided to shoot, that window had to come down further. Now, am I taking it too far on that, or is it common sense that it's December 3rd, it's cold, it's wet and rainy? I don't think they're driving on an interstate, which is creating even more wind, with the window all the way down. Don't buy it. That window was cracked, I believe it. It came down further when they needed to shoot.
Well, I agree with you what you're saying 100%, but you're being Detective Barris, not juror Barris.
Well,
Okay.
but I'm going toward the credibility of what I heard him testify. And every juror has to decide whether they believe what someone's saying. I'm not taking it, and based on what I just said to you, raises questions about Hill's credibility in saying that window was already all the way down.
I think that whether the window's up or down, I mean, we're getting lost in the minutiae.
Well, I'm just saying, it shows premeditation if you're like, pull up, I want to shoot, and one of them lowers the window the rest of the way to shoot.
Well,
that's clear premeditation.
Credibility is a real issue because, I mean, we heard the tape-recorded interrogation of Hill. He has never met Cowan.
Yeah, he contradicted himself
and
and
now
lied
we find
constantly.
out they're blood cousins.
Right.
Okay, so I mean, clearly there's been lots of inconsistent statements here,
Yeah.
and of course, they're in the jury charge. I think it's in number 41 of the jury charge, or 42, that the judge has told them in that long list of instructions that you can accept all, a part, or none of any witness's testimony. So just because a witness lies doesn't mean that they're out. The whole thing is out. Again, they're free to accept all, a part, or none of any witness's testimony.
Where you subjectively have to make that call. I mean, you're right. And I see some people here, Nala and some others, saying, hey, I smoke sometimes and roll my windows down, rain, sleet, or snow. I don't think you roll your window all the way down on the interstate in rain, sleet, and snow when you sneak. I don't buy it.
Well, it's 70 miles an hour.
I think it's
enough.
cracked, but don't tell me you're going 70 with the windows down in rain, sleet, and snow. Yeah, it's cracked, but it ain't all the way down.
Well,
not a
right,
chance.
because even at 70 miles an hour, it's enough to get the smoke out.
Right.
When it's cracked,
Yeah, okay. Let's go to, again, common sense, folks. Bobby. Bobby, good afternoon. Hi, Bobby.
How you doing?
Good. What's on your mind?
I just want to know why they don't fall in the category of reckless homicide.
Okay.
Good point. Good point.
How
Well,
about that?
so that's a great point. And of course, nobody on the defense team really told the jury. I'm a believer. Tell the jury what you want, okay? Especially in a civil case, you talk about this is how much money we want. This is what the number you would put in the blank, and they could have even taken the verdict form and said, "Hey, you go right here and check this box." But they were instructed on reckless homicide. They were instructed on first-degree murder, second-degree murder, facilitation of first-degree murder, facilitation of second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide. So the jury has that to consider. But Jan Norman did point out a really good point, and she hammered the point. You must consider the indicted offense first before you move down to lesser included offenses. But they were instructed on the offense of reckless homicide.
Good answer. Let's go next to T. T, good afternoon, T. Are you there, T? Oh, it's Anita now. I'm sorry. Anita, are you there, Anita?
I'm here.
Hey, go ahead, Anita. My mistake. Go ahead.
I've been listening, and I'm going back to where you all said that Cowan, the driver, no, Hill, the shooter,
That's right.
was sitting in the passenger front seat. But you don't know that. He could have been sitting in the back passenger.
Amen.
Okay, and what difference does that make?
It doesn't really, because you know what?
It makes no difference.
There could have been more than two people in the car also.
There you go.
Well, there's no evidence of that. Talk about jumping too far with your conclusions. There's absolutely zero evidence. In fact, you have Hill himself saying it was just the two of them in the car. He's not hiding anyone else.
Hill did say that. You're right.
But to me, you're right. I mean, I guess, Nick, you make a point. If I'm assuming, but whether he's in the front or back seat makes zero difference to me.
It doesn't, but it does. It makes a whole lot to Cowan.
How?
Okay, because if you're sitting beside me with a gun in your lap, I know that you're on. I'm going to watch you do this. Okay, but if you're in the back and I'm in the front driving and I'm not paying any attention, I'm not really able to see exactly what you engage in and what you do.
I think I would hear 6 gunshots.
I didn't say you wouldn't hear it.
And it would freak me out, and I'd know exactly what you're doing.
I didn't say you wouldn't hear it, but again, that's the difference in facilitation and criminal responsibility, is that he didn't act with the same mental culpability that it takes for criminal responsibility, but for facilitation, he aided or assisted in
If that was the case, then, I mean, and I think it's pretty much a given that he was in the front seat, because why the heck then did the defense not hammer on that more? Why didn't we hear that from Munkabo? Oh, by the way, we don't even know if he was in the front seat. We never heard that from Munkabo.
Well,
you think he might have wanted to mention
you know
that?
why he didn't ask that? Because
Why?
probably he was in the front seat. It was hurtful, okay? But again, you can only consider what comes out of that witness
Leave it out
stand.
there hanging.
But
Okay.
I mean, clearly, that's why he didn't ask, because, if we have, then all of a sudden we have Mr. Hill sitting next to Mr. Cowan with a gun on his lap. That's not so good. So
Interesting.
Don't ask questions on cross-examination that you do not know the answers to.
Great lesson there. Let's go to Mark. Mark, good afternoon. Hi, Mark.
How are you?
Good. What's on your mind?
Okay, you guys just brought up a very valid point. Now, the fact that he was riding around with a gun in his lap. Now, this guy that said, "Hey, man, what are you doing?" Do you think at some point he would have said to him, "Hey, man, why are you riding around with the gun in your lap, man? Put that thing away." And another thing I want to say is, he's hanging with a guy who shot his grandmother.
I agree.
So you tell me, you think he didn't have nothing to do with that? Thank you.
So the lesson to be learned from Mr. Hill's testimony is, and it's up to Mr. Hill, you can't blame his lawyers, it's solely up to the defendant whether or not they testify on their own behalf. But when they open the door, to the jury knowing that he shot his grandmother, a 6-year-old, and a 12-year-old cousin, it's over.
And we don't
It's
know that
absolutely
Cowan
over.
knows that himself.
No, we don't know
He may
that it's
not know
over.
that about Hill.
But here's the other thing. If you're Cowan, you're a felon. You can't be around firearms. And so if you get into my car and I'm a felon and you have a gun in your lap, I'm going to say, Barris, get out of here. I'm going to get 10 years at 80% in the federal penitentiary because I'm around a firearm. Get out of my car.
Right.
But gang members don't operate that way.
Yeah, different mindset. All right, let's go next to Gary. Gary, good afternoon. Hi, Gary.
How you doing, Nick?
Good. What's on your mind?
I'd like to say, in order to prove the window was all the way down, at 6 o'clock in the morning, the DA should have checked to find out what the temperature was. You cannot ride in the front seat of a car or a back seat at 70 miles an hour with that window down. There's no possible way. You would be freezing to death, especially if you was in the back seat.
Maybe. Now, again, it was in the evening, not the morning. Now, you could have the heat cranked. All right?
Hey, maybe there was a sunroof.
Maybe there was a sunroof.
I mean, see how this goes.
So, yeah, again, we don't have the answer to that. So, I mean, what we're throwing out here are things that the jury may or may not be considering. I mean, everything everyone here on Facebook is saying,
it's legitimate.
It's legitimate. I mean, and we may agree or disagree, but the jury could be considering any one of these factors we're talking about. And do I know? I don't. Do you know for sure? No. The jury will have to be the one that decides.
One thing we do know is that there was not any cracked glass on that Cadillac, because when Miss Reese testified, we saw it pull in from the side that would have been shooting towards Miss Kaufman's car. There was no cracked glass.
Yeah.
The windows were up. You remember they were tinted.
That's right. Let's go next to, I think, Michael. Michael.
Yeah.
Hi, Michael. Good afternoon. Are you there, Mike? Might have lost Mike. We'll see if we can come back to him. We'll go next to Tom. Tom, good afternoon, Tom.
Hi, how are both of you gentlemen? Thanks for your coverage on this. I have fought I-440, and it was originally Parkway 440, since 1987.
That's right.
And there are so many choke points on that highway, but the two worst are when you get off of I-40 West coming into that S-curve.
That's right.
Which merges.
Sure.
Before you get onto 440, there are three lanes.
Right.
400 yards back from the one lane that it chokes down to. Every day I have been on that road. Every day I fought Hillsborough Road coming out of south on Hillsborough Road. Now, was the prosecution not permitted to mention Hillsborough Road because he infers that he shot immediately as they were cut off? And that would have given you the impression, for those of us who are Hillsborough savvy, we know that that curve has been bad. They've corrected it numerous times with widening of the road and paving, because there are two lanes coming off of Hillsborough, one north and one south, that go into one lane, and then the merging lane, which the nurse would have been coming into, she would have been coming into that single lane. And so it gives you the impression that that's where the choke point was. I submit that the choke point was back where 440 and 40 come together.
That
or
makes
65.
Yes, and I know exactly. That makes more sense. And the congestion is there. Look, I don't doubt that was a tough thing. Something she may have not even realized she cut them off, and they probably did perceive that they were cut off. It's just you don't shoot someone for that.
Well, I mean, I don't know that I'm Hillsborough savvy. I grew up across from Panorama Apartments,
Okay.
somewhere East
Yeah, a
Nashville
little
savvy.
different.
But I
Sure.
will say that there was testimony that there were shell casings at the corner of Sharondale and Hillsborough Road, and then they were heading to pick up Mr. Cowan's girlfriend, who worked at maybe an assisted living at 115 Woodmont Boulevard. And so there was some text back and forth just within minutes after Kaufman had been killed and the car had stopped, the phone had stopped moving, and the response was, "I'm at the light," which tells me that they're waiting there at Hillsborough Road and Woodmont to either go whichever way they need to get to 115.
And you believe they threw the shell casings out of the car at that location because they were in the vehicle and they wanted to get rid of it?
Absolutely. I think that's what they did. That's why they went to great lengths to mention it.
I mean, just to be, I guess they were recovered. It's amazing that they were found later, but I mean, There's better ways to dispose of evidence than
Well,
throwing it out the car
there's
window.
better ways to get rid of a murder weapon than
giving it to
Mr. Odom. I mean,
yeah,
that thing would have never floated up from the bottom of the Cumberland.
Yeah, it made a lot of mistakes, and for the prosecution, they took advantage of that for sure. Let's go next to Tom. Tom, good afternoon. Hi, Tom. Are you there, Tom? Are you there, Tom? Are you there, Tom? Whoop, Tommy hung up. Let's go next to David. Hey, David. Good afternoon, David.
Oh, Nick.
Hey.
I've been watching this pretty much, trying to keep up with it already. You know, two people in a car, and this one said over there, he's got a pistol laying in his lap. He don't have it under the seat or in his holster. He's got it in his lap, so therefore that means he's on the ready. He's ready to put his hand on that gun and use it. And he's taking the blame for this, so he says the driver had nothing to do with it, but that driver, you know, you get in my car, I control what you do. He could reach over and grab that gun when he raised it up to stick it out the window. You know, so I don't see why in the world that jury can't convict both of them for murder. Driver's just as much involved as that shooter.
Okay. And David, that's the state's theory, and that's what they want the jury to believe. And I don't disagree. I mean, he's operating the vehicle. I mean, if you and I were riding down the road and you shot 6 times, I'm pulling over like I've been shot. I'm thinking, what in the world has just happened? You can't hear. You have, your ears are ringing, and I think I may have been shot. I mean, clearly, this is, I mean, that's the inference, and that's a strong inference.
Let's go next to Becky. Becky, good afternoon. Hi, Becky.
Hi.
Hey.
I'm nervous about doing this, but this call is for Caitlyn Kaufman's parents. We talked about what these two guys might get life. Well, they've given Caitlyn Kaufman's parents, both of them, life, because the rest of their life they won't have their vibrant, intelligent daughter who was a nurse, but probably would have been a doctor down the line. I think I'm not giving much emphasis for those that took her life. That was not necessary, but I do feel for the Kaufman family, period. Thank you.
Thank you, ma'am. And of course, thank you for that call. Never do we forget the victim in this case.
And we get so caught up in who did what and who did this, but the reality is we're all here because this young lady, who was, by all accounts, a phenomenal young woman, whose life was cut short by a senseless act of violence.
And the key word, it's just senseless.
And it's horrible.
Hill himself says it was senseless. I mean, lost his cool and did something reprehensible. I mean, it's just so senseless. It just didn't have to happen.
No.
It's just heartbreaking, and watching her parents in there, it's thank you for your call, ma'am.
Yeah.
We'll go next to Eileen. Eileen, good afternoon. Hi, Eileen. Are you there, Eileen?
Yes, I'm here. Thank you. Thank you for taking my call.
Sure.
One point of observation on my part, you all were talking earlier about sheer common sense, whether, that common sense dictates that he's in the front seat. We don't know that factually. That common sense would say that he was. Also, common sense, if you have a gun, I don't know how much that gun weighs, but if Cowan, quote, smashed on the brakes, that gun most likely flew at a rapid rate onto the floorboard.
Good point. Good point.
And so, if he had a piece of Kleenex in his hand, Kleenex may probably not have flown on the floorboard, but I can't tell you how many times I've had my purse in the passenger seat and I've had to slam on the brakes and there goes my purse flying.
Sure.
So then, in that instance, if that were the case, then he'll have to say, damn it, or whatever he said, excuse my language, had to, if he was wearing a seatbelt, unbuckle his seatbelt, crawl down on the floor, grab the gun, retrieve it, roll down the window even more than it was cracked, to point the gun out. So that gave him time. That gave Cowan time to say, man, what are you doing? Stop. But he didn't. I don't know for a fact that the gun flew on the floor, but I know physics would dictate that if in Hill's words, he smashed the brakes, one would imagine that that gun went flying.
I have not thought of that. And you know what she's doing? She's playing detective too. Well, and that's, I think, an excellent point. I mean, but we don't know for sure, right? I mean, did it fly off?
But one thing I can tell you is I accelerated this morning with the coffee and the cup holder, and it flew out.
It's happened to us all.
You know, things. Yeah, it's a
good
good
point.
point.
Does that make sense to you? And would that then maybe tie in, as she said? Well, at that point, he's frustrated. He has to reach down to get it. Then I mean, there's more things being done. Because a lot of people, if you believe the defense, then okay, and the argument is, got cut off, and he just immediately in a flurry was just furious, and just boom, 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 and then without even thinking, that would be a fit of passion in that moment. If it flies off and he has to reach down to get it, and then of course put this down, catch up and shoot, there's more premeditation there.
Well, that's right. Remember, premeditation can be formed in an instance, and that's more evidence. If he had to reach down the floorboard and pick it up, clearly that's more evidence of premeditation. And we don't know the answer to that question, but there were some facts the defense had to sort of work with here. Maybe they had a little more savvy client, to be honest with you.
Okay. Dominique says he probably clutched it when the brakes were hit. Natural instincts. I don't know, if you put it in the clutch, maybe it reduced the ability for the car to lurch as much. But again, you heard Hill say, it was pretty dramatic what happened, because he had to swerve to avoid her. They were cut off.
Believe Hill.
If they believe Hill. All right, let's go next to Annette. Good afternoon, Annette. Are you there, Annette? Is that line 2?
Oh, here I am.
Hey, go ahead, Annette.
I've been listening to the whole trial, and I don't think that they deserve first-degree murder, because nobody knows the mindset of anybody. I don't believe they went out intentionally looking for Caitlyn to kill the young lady. Also, we're sitting up, they talking about he had a Bible in his hand, where they think that's orchestrated. I do know that even though they may be gang members and all that people gang members do believe in God, because they have to believe in God to know that there is some way they're making it from day to day. I don't judge people the way I've heard of a lot of the comments on here today and the past few days. We could judge people. They could say that the same people, when we was in slavery, that was orchestrated. Y'all saying that him holding the Bible is orchestrated. But I don't believe the way that those guys, just because they're gang members, that they should be judged because they are Bloods or Crips, because I know Bloods and Crips have did some good things in communities also.
And you know what? And she's right about that. First of all, we don't know his motives behind the Bible showing up just today. We didn't see it maybe earlier in the trial in his pocket. But the idea of Bloods and Crips being introduced, and we don't know that there's any connection with the gang membership really to the actual shooting itself. No. But it seems to me like the prosecution wanted to find a way to get that in there one way or the other. And the inference would be that a jury might think, well, if they're gang members, they're more capable of this violence. Is that fair?
I'm not saying it's fair, but you got to understand that, the prosecution is going to pile on with whatever they got. That's their job, and some people call it cheating or whatever you want to call it, but they're after you. They are literally after you, and with a charge like this, they're going to throw everything they can, at you they can, and that's their job. But I do agree with you, Annette, that I don't think that they were looking for Caitlyn. No. I don't think by any stretch of the imagination either one of these young men meant to shoot Caitlyn Kaufman, but they meant to shoot whoever was driving it, not Caitlyn Kaufman.
That part of what Hill said, I believe. He had no idea. I don't think he knew it was a woman behind the wheel.
But with that statement, he said that before he said that he didn't know it was a woman, he said that, I don't think that she didn't even see us when she came over, right? Mm-hmm. And then he said that it was a woman. So, and it may be because it was just the use of a pronoun, maybe, and I'm reading into the timing on that.
But again, though, and I appreciate her comments, but as far as being judged here, Hill is already admitted to shooting and killing her, and he will be judged. The question is how harshly. And there's no question he should be judged. He murdered this woman, and you have her family in there. There needs to be a judgment coming, and it is coming.
And he shouldn't be judged on the gang affiliation. No,
I
agree
separate.
with that.
Yeah.
No, but he should be judged in the fact that he says, I don't know Cowan in the videotaped interrogation, and then there's a picture of them together at a party. Then he testifies and says we're actually related by blood, we're cousins. I think you should be judged on that for
Right.
sure.
All right, let's go next to Michael. Michael, good afternoon. Hi, Michael.
Hey, how you doing? Can you hear me?
Yes.
Good.
Yeah.
Okay, I gotta get out here and go to work, but I really think this is highly stupid and pathetic. There's no excuse for what these men done. They deserve life. Now, just imagine my daughter, your daughter, the government daughter, the president daughter. What if that was their relative car? You think they would have shot up that car? No. Oh, stop, Rick or James. That's Helen's car. No, they had that gun on them. They knew what they was doing when they was driving. Quit spending the taxpayer money on people that are murderers. These kids knew what they were doing. Why are you driving around in the rain with a loaded firearm? Don't tell me you do not have to do something. You didn't have to shoot that car. And now you want an excuse to justify you because you're caught in everything that y'all done and you want mercy? No. Actually, if it was up to me, the chamber. They killed that child. What if it was your grandmother in the car? Come on, please.
Gotcha. Well, and that's...
Well, I mean, if it was Hill's grandmother, he wouldn't have cared. He shot his own grandmother. So I don't know.
As a matter of fact, he did. We found that out in testimony. But that's where I think, especially when it comes to Hill, I think the jury feels exactly the way Michael feels.
Yeah.
I think that's it. With Hill. Cowan, again, we will see. I think we both agree that might be where there's some debate. And by the way, the jury broke out around 11:30 or so, was when they were done and sent off. We think they probably moved the evidence stuff back there that they needed and then went and had
clearly
lunch.
they're deliberating.
Yeah, by now they're definitely deliberating.
Yes.
We're going to call it around 15 to 12:30 is probably when they started. Judge didn't want them deliberating while they're eating. So they're in it now. They're deliberating as we speak. If anything happens in there, we'll let you know. We're going to take a few more calls here. We'll go a ways, and then we may break around 1-ish or so and just kind of go to regular programming while we monitor things there. And then we'll break back in, give you updates, and take some more calls. But we'll continue now since a lot of you do have questions. And we'll go next to, I think, T. T, do we have you back on the line? T, are you there?
Yes, I am here. Hey, Nick. Hey, Mr. Leonardo. How are you?
All right.
Hi.
So I got a bunch of things I want to say. So if you cannot place me on hold, I got like 5 different things that I wanted to say. I do want to start off by saying it's sad that Caitlyn Kaufman has passed away, and she came down here to follow her career and passed away 2 years later. What I don't understand is how they're trying to paint the picture and say that Hill is covering up for Cowan when he's taking responsibility of his charge. Now they're always saying, come forward, you should say this, you should say that. No, he's just being a man and telling what he did. Cowan was at the wrong place at the wrong time with the wrong person, and ultimately he's dealing with that situation. That's just like me. If I'm driving in the car, if my sister's driving in the car and someone is with me, she's with me, and I end up shooting, my sister isn't involved in that. Yes, she can't report that, but you also have to understand too, Cowan had a record. So let's just say if he was to go and report that to the police, who's to say that he wouldn't be in jail? And, they're trying to, the whole gang thing, and y'all have touched on this, throughout the trial about the gang, and now it doesn't matter. But if you all want to say anything about a gang, or it could be gang related, Jacquees was in a gang, and if it was any type of gang relation, don't you think that he would go, Cowan or Hill would go find a local blood member and cut them up, shoot them up, or do anything? Why would they find an innocent person on the interstate to hurt? Secondly, a lot of these drivers, that cut people off are the same drivers that, are in Brentwood now. I'm not gonna, kill somebody or get that mad. I've had my shares with, they cut me off or they blow the horn or they won't let me over. You have simple rage, but I wouldn't do it. But a lot of these callers are making it seem like he should be in jail or he should do this. Yes.
I just want to ask you then, I understand your point. So are you saying you don't think Hill did anything wrong here?
No, by no means am I not saying that he didn't do anything wrong, but I'm saying the wrong charges are being placed on him simply the premeditated murder. Now, reckless homicide or involuntary murder, that should be on him. But for them to put that on Caitlyn, I don't think that that's fair. Yes, he was at the wrong place at the wrong time, and he admitted to what he did. And how can they say that he's lying? Nobody was in the car. Only them two know what they did. And it's sad that Caitlyn and her mom has to continue to go through that or listen to that or see everything, because she was a young lady that was chasing her career. And I simply understand, because if it was someone, if it was someone in my family that was murdered, I would definitely understand that as well. But we have to be fair and put the right charges on the right people. That wasn't premeditated. Now, premeditated is if they plan to go do that, knowing they would do that. Okay, so the charge would be cool for Caitlyn, but I just don't think a lot of this is fair. And I'm sorry, this is my last thing. I apologize. When he was on the stand, and the DA, Norman, whatever, the questions that she asked, he stuck to his story. He didn't really switch his story. Like, he didn't really lie. Like he said, I'm owning up to what I did. He didn't have anything to do with it.
Yeah, fair enough. Listen, I appreciate your calls, and it's possible that the jury sees some of it that way, especially when it comes to Cowan. It's just that we talked earlier about what criminal responsibility is in the association and the circumstance. She talks about she and her friend driving and with one shot, but I'm guaranteeing you, one, they're not gang members. Two, her friend's not driving around with a 9mm in their lap with the history that these two had. It creates a different scenario. People are different.
Well, so two things, I guess, T, that stand out. One is that you don't ever really get a chance to understand or know the law until you find yourself involved in it. Of course, as a lawyer, I do this all the time, but premeditation can be formed in an instant. So it's important to point out that that they don't have to have planned to do this. I mean, you could form premeditation just like that, and that's what the state's kind of relying on, is that this was really formed. The premeditation was formed at an instance, and then the jury was instructed on reckless and criminally negligent homicide. So those charges, were instructed.
That is an option.
That is an option for the jury to consider in this particular set of facts.
Yeah. Again, different points of view coming in, and that's why I appreciate hearing from people like T and others. Just, you wonder, is there someone on the jury feeling that way? And if there's someone like some of these other callers, if that's the case, then we're going to have a longer deliberation.
Well, and I will tell you that, Cowan could have got up there and told his side of the story, but for the fact, this is the unfortunate part. What Mr. Hill said could indeed be the truth, and Cowan may be just dying to tell his story, but the problem is he's got, several other felony convictions for robbery and lots of drugs and guns and, being a felon in possession of a gun. And so, because you have those prior offenses, it puts you in a really delicate spot to not testify, which I think was the right decision.
I think it was the right move.
Absolutely the right move. But, he could have told his side of the story if he didn't have a lengthy criminal history.
Let's go next to Pauline. Pauline, good afternoon. Hi, Pauline.
Hi, Nick. How y'all doing?
Good. Right. What's on your mind?
What's on my mind is there's no excuse for either one of these guys. Because if I was driving, number one, if I see me and my sister was driving, and somebody got in the front of me, if I'm the driver, and she's sitting with a gun in her lap, number one, I want to know why you got the gun in your lap in the first place. Is it that you're scared, or are you looking for a victim to shoot at this time? So, number one, the driver had time to slow down, let Miss Kaufman get on to where she was going, then start back on his route. But he speeds up and catch up with her to give Hill a chance to shoot. Can you answer that for me? Why would you think that you ain't part of the situation if you're the driver? If you're the driver, you got control of the steering wheel.
Mm-hmm. Yeah, and you want to know why. I hear your point there. I guess it has to come down to what you believe. Do you believe he just accelerated and was trying to get out of there and Hill shot without him having any idea, or do you believe he accelerated to pull parallel and allow Hill to shoot and was part of it?
Well, that's right, Pauline. That's what the state wants you to believe. Now, the difference is the culpable mental state and the intent of Cowan And those that what you believe to be the culpable mental state, or what you think his involvement may have been, would be the difference in him being criminally responsible, or maybe him being guilty of a lesser charge like facilitation.
Yeah. By the way, on cross-examination, Jan Norman did ask Hill, about the gun in his lap, and he said I guess it was in his pocket or on his hip.
It was uncomfortable.
And he just said it was uncomfortable. He just said, I put it on my lap because I couldn't really get into the seat comfortably with it there. So the lap, I guess he could have put it in the glove compartment or someplace else, but that was his explanation. It was uncomfortable. It was on his hip, and that's why it ended up on his lap, for whatever, better or for worse. Let's go next to Andy. Andy, good afternoon, Andy.
Hi, I just have a couple of questions. How come the state didn't go for the death penalty? And also, would that still be an option when they come back for the judge to hand that out? And how long actually will it take for the judge to sentence after they come back?
Okay, good questions.
So the state was not seeking the death penalty here. They have to let the defendant know that well in advance. And this set of facts, the way that I've heard them, I don't believe that it would lend itself to the death penalty, because there have to be some other aggravating circumstances, such as, the person was mentally incapable, they mutilated the body, it was especially heinous, atrocious, and cruel. It's a child, other things like that. But again, it's up to the elected official in each jurisdiction whether they're going to move forward with the death penalty. And General Glenn Funk has made it clear, at least so far, that he is not going to move forward with any of the death penalty, or move forward with seeking the death penalty now as it pertains to sentencing if these individuals are found guilty of first-degree murder today. The judge could go ahead and impose the life sentence, but under Tennessee law, even if she does impose it today, within 45 days there's got to be a sentencing hearing, because what happens is that the Board of Probation and Parole would put together what's known as a pre-sentence report, and that's where an individual goes out, meets with each one of these defendants, talks about their criminal history, gets them to write a statement as to whether or not what was their involvement, and then there's a couple of tests that they started doing here recently to try to predict some recidivism, or whether or not they're going to reoffend. And so the judge would take that pre-sentence report, as well as the proof she would hear at the sentencing hearing, to fashion a sentence within the range based upon whatever offense they're convicted of. So again, they have 45 days in which to come back for that sentencing hearing.
By the way, that sentencing hearing would be a chance for the family members to speak as well, which is always very emotional, but you'll hear from the family to talk about the loss and how this has devastated their family. And
we heard from Caitlyn Kaufman's mother as the first witness, right?
That's right.
And she had to have something more than, my daughter has gotten killed. She would talk about when the last time she spoke to her, what she normally speaks to her, and how she knew something was wrong. But when it comes back for a sentencing hearing, then both mom and dad could get up there with pictures. They could have siblings, to some degree, get up there and talk about what this loss has meant in their life, and really get into things they might not be able to get into in a guilt or innocence phase.
Those would be victim impact statements.
Victim impact statements.
Could you also hear testimony from family members of the defendants?
No, you could call them. People do that all the time, to call them as character witnesses, or to call your mother and say, he's a great kid, he's or I was a bad mom, or this mitigates kind of the behavior, or and it's always not murder. There's a lot of sentencing hearings that happen on low grade felonies, and a lot of times it's your second or third bite of the apple on a drug offense or a property crime, and the judge could sentence you to jail. The judge could let you walk out of there on probation. And so clearly, hearing from the defendant's family, the defendant's employer, somebody out there that says, listen, this individual's worth taking a chance on. I don't think they'll be back, and this is what we have planned should Your Honor decide that a sentence of an alternative sentence, one that would be placed upon some sort of supervised release, is the appropriate remedy here. And so you certainly would have family members testify in their behalf.
Gotcha. All right, let's go to Tim on line 11. Tim, are you there, Tim? Hi, Tim.
Yes, I'm here.
What's on your mind, sir?
Well, first of all, I want to say thank you for your gavel-to-gavel coverage. It helps me to utilize my 4 years of night law school.
Oh, Tim, you went to Nashville. You went to Nashville School of Law, did you there, Tim?
Yeah. Matter of fact, I won the moot court award, but I never went into practice. I used it as a supplement for my business.
Oh, so a law degree is good for anyone to have.
That's what I was saying.
Yeah.
I'll tell you what's good for all lawyers to have, and I had the privilege and maybe learn more about the law, and from minute to minute was to serve on a jury and a grand jury.
Oh, wow.
And I really got a real education, but yet all my attorney friends, I have yet to find one that has served on a jury, criminal or civil. They normally get kicked out, or they get out of the duty or get kicked out on voir dire. In my particular case, I never indicated to anybody I had a law degree if I served on the grand jury or on the regular jury. But one of the things that did bother me, and quite frankly, y'all touched on it, and thank you. I'm a law and order guy, and I don't, throwing the book at them is too good for me. But in the spirit of my law degree, I thought it was unconscionable they didn't sequester this jury. Especially, I watch Channel 5 all the time, Nick, and of course I used to go to the YMCA before I moved up here to White County over in Donaldson, see you and your wife over there. And quite frankly, Channel 5 ran a story last week about that Christmas Day unsolved, and I noticed the assistant attorney general said, I wished every crime had
that kind of reward money. Yeah,
that kind of reward money. To be so naive to think the jury is not exposed to that, one of your callers, it's like being naive to think that your top officials, a lot of them are lawyers that don't take classified information home with them. It's just too naive. And it's not, y'all indicated it might have been it's not complicated. And a trial this short, all they had to be was sequestered. And Nick, I know you used to be with the court system. We were treated, I was on a sequestered jury, and that's one of the fondest memories of my life, is how well I was treated and the experience to go in. And I will say this, the thing that really gave me a big education is how serious the jury members take the charge of the judge and the consideration of the evidence. I was really impressed with that. But thanks again for your great coverage.
Tim, when did you graduate from the Nashville School of Law? What year?
I graduated in 1982. Matter of fact, my study partner became a prosecutor over in Cannon County. He's retired now, and now his son is a prosecutor over in Rutherford County, I understand. But it was a marvelous experience, and I happen to think that the book that Nick brought up, I want to get a copy of that for my TV table. So on the criminal, it's been a while.
So you can go to the administrative office of the courts.
Yeah, show the book just for folks that didn't see earlier.
Well,
and thank you, Tim, for your call. It's good to hear from you. But
this is an older version. We have a newer version out, but it's the Criminal Justice Handbook, Tennessee Criminal Justice Handbook. And if you go to the administrative office of the courts, I think it's like $42 or $46 or something. You can purchase it, and they will send it to you.
Breaks down all the laws,
all the criminal laws, the rules of evidence, and everything like that. And shout out to Nashville School of Law. I mean, that's where I went, and it's done. It does a lot for a lot of people. 80% of our judges are graduates from the Nashville School of Law.
Oh, and, some terrific lawyers.
But as it pertains to sequestered juries,
go ahead. What about that?
You have to request a sequestered jury, and I don't believe that request was made in this particular case.
Can either side request defense or the prosecution, or is only the prosecution requests it?
Either one can. And when I was, I've had sequestered jury trials as a attorney. I've had two. And they were out of county, but I've also participated as a court officer who was broke in law school. And I will say the sequestered juries here in Nashville, they eat exceptionally well. I felt like I might have put on a little weight. I mean, the spreads are great. I remember as a young law student, not having any money, but that was part of my job, is to be with them.
You don't make much money being on a jury, obviously. At the very least, they can do is feed you well.
Yeah, and they do, But I would agree with you. That's something that maybe they should have considered doing. But again, I don't know that we had a whole lot of publicity. I mean, there was publicity, but I don't know that it was as much as, say, maybe the Holly Bobo case or that Joe Clyde Daniels case clearly had a whole lot more publicity surrounding that. But the Judge Dalton did not have a gag order, but she sealed the file, and so that prevented good reporters like Nick Barris from being able to get exactly what was going on.
Yeah, don't find out till trial. Just with regard to this, I think we both can concede that these two defendants will be found guilty of something. There's not going to be acquittals here. Right. If you think there's going to be acquittal, you're living in a dream world.
And if there was, it's over.
Yeah, it's over. There's no double jeopardy. jeopardy. But it's unlikely there's going to be an acquittal for either. We can discuss what the charge and conviction may be. But if and when this happens, they'll both be eligible to appeal, correct?
Oh, yeah, so absolutely. We got
someone was asking about that.
We have a three-tier appellate process in the state of Tennessee. The first one would be the fact that you have a direct appeal. So if you're convicted, that conviction will be reviewed by the Tennessee Court of Criminal Appeals, and then after that, you can ask the Supreme Court to review your conviction, but that is discretionary, and they take about less than 10% or so of the cases that people, both civil and criminal, of cases that people are seeking review under. Then after that, that's one aspect. The other one is a post-conviction proceeding that happens after the direct appeal, that you try to allege that your attorney was ineffective during trial. If you're successful, the conviction gets overturned. And then the third tier of appellate process in criminal cases that we have is habeas corpus, and those appeals are unlimited and could start as early as yesterday. Okay,
and that's a given. That will come up. Listen, here's what we're going to do, Nick. I worry about your blood sugar. We're going to get you some lunch. I don't want you getting hypoglycemic. We're going to take a break here at 1 o'clock talking about lunch. We believe the jury was sent off at about 11:30. Okay, they probably had lunch. They certainly have been deliberating at least for the past half hour to an hour. So that is underway. We're going to step away, okay? We'll do some checking what's going on at the courthouse and the like. And then we'll get back with you maybe around 2 o'clock or 2:30 to update you on what's happening over there. If and when we get word of a verdict, we'll put it out on social media. We'll go in directly live. If there's a question from the jury and the court comes back, we'll take you back. You will not miss anything. For the moment, we're going to go to regular programming, but we'll be checking in with you. So keep tabs with us on social media. Keep watching here, and we'll have updates within the next hour or so. But the jury, busy deliberating as our gavel-to-gavel coverage continues in the Caitlyn Kaufman murder trial. Stay tuned.